Thank you, Your Honor. And then a secondary issue was that, given the testimony of counsel yesterday, they both admitted that they did not confer with Mr. Reinking on investigating the diminished capacity evidence or raising diminished capacity evidence, and which would give it an opportunity for lesser included offenses. And given that, that's a respectfully submitted to the court of McCoy versus Louisiana issue that the defendant has to have a right to make the course of the defense. That's part of this amended motion that we're going to file. Just, we're trying to basically conform our pleadings to the proof as it came in. Thank you, Judge.
Understandable.
Your Honor, at the outset of our second amended motion for new trial, which is lengthy, and we will not argue every issue there, but we stated that this entire case, unfortunately, was infected with defense counsel's failure to conduct an independent investigation into Mr. Reinking's mental illness and the evidence of that mental illness. And it was the failure to do so, to conduct that legal research, to conduct that factual research, that rendered any strategic decisions that they made uninformed. And any strategic decisions that they made concerning that are entitled to no deference whatsoever. I have known trial counsel in this case, at least Mr. Bruno and Mr. Evans. I've known Mr. Bruno for over 20 years. I've known Mr. Evans for over 10 years. And one can be a very experienced lawyer and still not be experienced in a particular case or make wrong decisions in a particular case. And so I don't say that they are inexperienced counsel or are not outstanding criminal defense counsel. None of us are perfect, and we all can make mistakes. This was more than just a mistake. It is something that rose to ineffective assistance of counsel because of the failure to conduct the research and the investigation necessary so the strategic decisions about how to handle this very complex case were informed. I've got a few slides, and I know the court is able to see those. The testimony the court has heard and the evidence before the court is that the mental health investigation in this case began when John Wing with the Public Defender's Office was involved in obtaining a court order for an outpatient competency and insanity evaluation by Vanderbilt in General Sessions Court. And an evaluation was done by Vanderbilt, and Dr. Wood made findings. There was a referral over to Middle Tennessee Mental Health. The court's well aware of all of that information. And on October 15, 2018, there was the report finding that Mr. Reinking had been restored to competency after months of hospitalization at Middle Tennessee Mental Health, but that he was legally insane at the time of the commission of the offense. He was medicated, sent back to the Davidson County Jail. So from October of 2018 to January of 2022, there was no other investigation done into Mr. Reinking's mental state or mental illness. Defense counsel had every opportunity to do so. They had every ability to do so. And as the court is aware, once successor counsel became involved at the motion for new trial proceedings, as soon as the security classifications were such that Mr. Reinking could have psychiatric, neuropsychological testing done, the court now knows the result of that testing. And the state maintains that it has never fought the issue that Mr. Reinking suffers from schizophrenia. But what is clear is that the state did fight that he was suffering from schizophrenia specifically at the time of the commission of the offenses. And that is a distinction with a difference here. As the court's aware, concerning the testimony that came in at trial, the testimony they presented from officers about their experience with schizophrenia and how Mr. Reinking appeared later when he was arrested. But the court obviously heard, and it's listed in Dr. Agarkar's report at page 15, his history of mental illness, going back to when he was psychiatrically hospitalized in Illinois for schizophrenia in 2016, with these same delusions about celebrities, about Taylor Swift, about being tortured, about being persecuted. And sadly, he suffered these delusions for years and reported them to law enforcement, was seeking assistance from law enforcement to try to stop his tormentors, went to the White House. The court's aware of all of that. The situation with the BMW dealership. And I've got the DSM-5 TR diagnostic criteria for schizophrenia. The court heard from Dr. Agarkar and Dr. Spica that Mr. Reinking has a severe case of schizophrenia. It's not even a close call. With his delusions, hallucinations, disorganized speech, grossly disorganized or catatonic behavior. I think they both said that disorganized behavior was the issue there. And Dr. Spica said it's negative symptoms. And the court has now the benefit of the neuropsychological evaluation. I've got up Dr. Spica provided converging and consistent evidence of neurocognitive deficits representing a severe mental defect, processing speed, memory retrieval, new learning. And Dr. Agarkar, who conducted his own evaluation of Mr. Reinking, he did not do neuropsychological testing, obviously. He's not a neuropsychologist, but he's a psychiatrist. And the court heard here that with respect to neuropsychology, it's not only the 5 years it takes to get the PhD beyond your undergraduate education, but then also effectively another 2,000 hours of training specific to neuropsychology. And that Dr. Spica had, I believe, what he called a cognate, for lack of a better word, specialization when he was doing his PhD in neuropsychology as well, and did residency with a neurology practice. Dr. Agarkar, of course, has 5 years of additional training in psychiatry on top of his MD. And so the court heard from these two experts, and Dr. Agarkar agreed. He says, I agree with Dr. Spica that Mr. Reinking suffers from impaired neurocognitive functioning with schizophrenia with active delusions. And both Dr. Spica and Dr. Agarkar say that that's not just a severe mental disease. That's a severe mental defect. And that's important because that evidence was not before the jury. That evidence was not before Your Honor. You didn't have that information as the 13th juror in the case, as the court who is ruling on the evidence and making determinations about what evidence is going to come in and how the jury is going to be instructed based on the evidence that has been presented by the lawyers. The legal insanity statute, of course, the court knows well. I've got it up on the screen. There's a few elements I have highlighted, Your Honor. The trial of this case focused on severe mental disease, schizophrenia, and inability to appreciate wrongfulness. That was an incomplete insanity defense presentation, and it weakened the quantum of proof in the defendant's favor. What was not presented was the severe mental defect, and as a result of the confluence of the severe mental defect and the severe mental disease, Dr. Agarkar and Dr. Spica both talked about this in their expert opinions, about how the severe schizophrenia and the neuropsychological disorders interact with each other and exacerbate what otherwise would just be the effect of the severe schizophrenia. And as a result, they rendered Mr. Reinking inability not just to be unable to appreciate the wrongfulness of the conduct, but also the nature of the conduct. And that's critical, but when, as the court knows, the evidence that the state was presenting to attack that insanity defense, and I use that language, alter the quantum of proof in the defendant's favor, that is language that is often used when we think about materiality with respect to Brady. There are several Tennessee Court of Criminal Appeals cases on that. One is State versus Husky. That's a case that originated in Knox County. It's a Judge Tipton opinion. It's about 300 pages long, given the procedural history in that case. But one of the things that Husky talks about is, with respect to Brady, is evidence that can alter the quantum of proof in the defendant's favor. And here's how that interplays with ineffective assistance. The standard, as the court is well aware for ineffective assistance, you have deficient performance and you have prejudice. And then how prejudice is defined is a reasonable probability of a different result. With respect to Brady, the issue is, was it not provided, and is it material? And how do the courts define materiality? It's a reasonable probability of a different result. The U.S. Supreme Court has said multiple times, materiality for purposes of Brady, prejudice for purposes of ineffective assistance are the same standard. And so when you take a look at those cases that talk about quantum of evidence in the defendant's favor, that's exactly what we're looking at here in this case. Did the jury hear that Mr. Reinking had schizophrenia? Yeah, they heard a lot about schizophrenia. The court was here. The court saw it firsthand. However, that was a fundamentally different presentation of evidence than one where you would have a greater quantum of proof for the defendant from a forensic psychiatrist who's well experienced, from a forensic neuropsychologist, and you've got disease and defect, and you've got to appreciate nature and wrongfulness. That is a fundamentally different strength of evidence that can be presented to the jury, particularly in a case where the defense has to bear the burden of proof by clear and convincing evidence. And I've got a couple of quick notes up about legal insanity, as the court's aware. Appreciate, the case law says that really means the ability to form a rational understanding. Nature, the cognitive capacity of what the actions were. Wrongfulness, knew that the actions were wrong. And as with respect to legal insanity, Dr. Agarkar, of course, has the opinion that he was unable to appreciate the nature or the wrongfulness as a result of severe mental disease or defect. And then, of course, Dr. Spica renders the same opinion. Severe mental defect of impaired neurocognitive functioning and unable to appreciate nature or wrongfulness, along with the schizophrenia. So let me go to diminished capacity. Diminished capacity, oftentimes lawyers will generically call that a defense. And as the court is aware and has heard a lot of testimony about, it's not a defense, it's a rule of evidence. And after the Insanity Defense Reform Act federally, there's a lot of federal case law on does that still exist, and all the circuits have held yes. Tennessee, we're well aware, followed suit, adopted a version of the Insanity Defense Reform Act, and the Court of Criminal Appeals in State versus Phipps dealt with that, and they said, look, you can still present diminished capacity evidence irrespective of insanity. And Phipps, I believe, was written by former Tennessee Supreme Court Justice Penny White when she was on the Court of Criminal Appeals. And the court in Phipps said, diminished capacity is never used as a justification or an excuse for a crime, rather is an attempt to prove that the defendant, incapable of the requisite intent of the crime charged, is innocent of that crime, but may well be guilty of a lesser one. And then our Tennessee Supreme Court in State versus Hall 3 years later had occasion to also take a look at this. And they say that such evidence should be presented to the trial court as relevant to negate the existence of the culpable mental state required to establish the criminal offense for which the defendant is being tried. I would note that even though Tennessee's pattern instruction, which you've seen me show and talk about, says that it has to be evidence of a mental disease or defect, I note, and I have on the screen for your honor, State versus Scott from 2009 from the Tennessee Supreme Court, that wasn't expert evidence of severe mental disease or defect. The Tennessee Supreme Court held that sleep disorder evidence, that the defendant was introducing evidence that he had a sleep disorder and he would sleepwalk on occasion, and that evidence was excluded. I believe that was a Davidson County case. That evidence was excluded by the trial court. Went up to the Court of Criminal Appeals. Tennessee Supreme Court took it and reversed and said no, that evidence should have been admitted because it was relevant to rebut the mental state required for the conviction. So diminished capacity evidence can be stronger or can be more than just evidence of a mental disease or defect. But we don't have to get there here. The court has before it evidence of a severe mental disease or defect. And looking at TPI Crim section 42.22, you just have to establish mental disease or defect, and it has to demonstrate the defendant's inability to form the requisite culpable mental state. Dr. Agarkar at page 33 renders that opinion. He says that he was suffering from schizophrenia at the time of the offense, a severe mental disease or defect. His mental capacity was diminished at the time to the extent it rendered him unable to form specific intent and premeditation necessary to commit the offenses. Now, the state's made much argument about not being able to form recklessness or criminal negligence, and we're all aware of those definitions. Those definitions still require some amount of conscious awareness. Even criminal negligence does. And Dr. Agarkar and Dr. Spica have both explained in their testimony and in what we've submitted to the court in their written reports and affidavits that Mr. Reinking did not have that conscious awareness at the time. He was in his own dream world, and the court knows one of the examples I use. It's sort of like having a virtual reality headset on. You're seeing a world that's not even there, but his brain also is so chaotic and so dysfunctional that he's not able to even operate rationally in the VR world that he's in at the time. And that's why they say he could not form that capacity. Dr. Spica, of course, makes the same finding. And so I respectfully submit to the court, armed with this evidence, whether or not the pattern instruction should be broader than it is given State versus Scott, which arguably it should be, doesn't matter. We meet the pattern instruction armed with this evidence, and if that evidence had been presented, whether it was got significant cross-examination or not, whether or not the state had their own expert or not, it would have been an issue fairly raised by the evidence, and the jury could have been instructed on it, and they weren't. Of course, the court's well aware of the definition of premeditation. I won't roll through those, or the definitions of culpable mental state that I have up. I've got a slide up about the interplay between legal insanity and diminished capacity, as the court's aware, and you heard me use this argument. It's sort of like in a way, kind of a lesser included type of defense. And I respectfully submit to the court that the two can be run in concert with each other. They're not inconsistent. It's not like us, what we were arguing about, or not arguing about, but using the example of inconsistent defenses, fundamentally inconsistent defenses. These are not fundamentally inconsistent defenses at all. And it's another way for the jury to consider the evidence. And as defense counsel defending a case of this seriousness and this significance, the more times you can get the jury to have a legal opportunity to consider the evidence that you're presenting, the better. And so, I respectfully submit to the court, it doesn't make any sense to reject running with a diminished capacity defense when you're going to run with legal insanity in this particular case under this particular proof. And even though Mr. Bruno and Mr. Evans testified that they didn't think they would run with both of them, that it might confuse the jury, the problem is they didn't investigate it or research it to be able to effectively make that strategic decision. That's not there here at all.
And therefore, no deference to their decision on it.
No deference to their decision on that. It was an unconsidered, uncounseled decision. Now, I told you I had a little snippet from Ake versus Oklahoma. Whether it's Ake or Aki. I've heard it pronounced both ways. I'm going to call it Ake. But obviously 470 U.S. 68, 1984, that is the foundational case that, as the court's aware, going back some history, as a result of Ake versus Oklahoma, Tennessee Supreme Court Rule 13 was amended for non-capital cases to allow psychiatric assistance and the assistance of non-attorney experts of a whole variety of kind, to include investigators. It was that critical of a case. The court will recall that before this case, in non-capital cases in Tennessee, you got no expert assistance for anything if your defendant was indigent. And so, but this case turns on the assistance of a psychiatrist to consult with the defense independently and ex parte, and to ex parte evaluate the defendant in order for the defense to be able to effectively investigate mental health defenses and mental health issues. And, I've got a parenthetical up. We all know the holding of Ake, but they specifically hold, and in some courts, I can remember when we were in a debate, the defense bar and the Tennessee Bar Association, and I remember the AG's conference, or the AG and the DA's conference were involved all in a discussion about amendments to Rule 13 several years ago. And one of the issues being floated around was that, well, technically, you're only just entitled to funding for a psychiatrist under Ake. A psychiatrist is what you get, because that's literally what it says. The court may recall some of those discussions years ago. But here, that's exactly what they needed. That's how fundamental this was to the defense function. And what in the world, if their only stated reason, the court heard that testimony, their only stated reason as to why they didn't even investigate this was because they were concerned the state may get their own expert. That makes no sense when you have the ability to investigate it without noticing anything. And the court heard, and I asked this question specifically of Mr. Bruno, you made that strategic decision absent investigating it. He said yes. You made that strategic decision absent researching it. He said yes. Mr. Evans admitted the same thing. Now, Mr. Evans' testimony was, well, maybe the state would see by looking at the jail logs who went into the jail, but then you heard me ask him, now hang on, under Ake, you could get an order from the court that instructs jail personnel not to disclose that this evaluation is going on. I asked him if he knew that was possible, and he said yes, he knew that was possible. So all of those concerns could have been mitigated if they had just tried, and they did not. The operative quote from Ake is pages 79 through 80, 470 U.S. 68. These statutes and court decisions reflect a reality that we recognize today, namely that when the state has made the defendant's mental condition relevant to his criminal culpability and to the punishment he might suffer, the assistance of a psychiatrist may be crucial to the defendant's ability to marshal his defense. I'm going to pause there, Your Honor. Marshal his defense. Mr. Bruno and Mr. Evans admitted, and you have the affidavits of Dr. Eisen and Dr. Wood, They did not consult with Dr. Eisen or Dr. Wood about what else they should do. They never asked them those questions. Dr. Wood and Dr. Eisen did not see themselves in that role either. And you have their affidavits before you that never did defense counsel even ask them those sorts of questions. And so the defense here, Mr. Reinking here, was deprived of a psychiatrist who could help to marshal his defense. In this role, psychiatrists gather facts through professional examination, interviews, and elsewhere that they will share with the judge or jury. They analyze the information gathered and from it draw plausible conclusions about the defendant's mental condition and about the effects of any disorder on behavior. And they offer opinions about how the defendant's mental condition might have affected his behavior at the time in question. They know the probative questions to ask of the opposing party psychiatrist and how to interpret their answers. And here, Mr. Evans and Mr. Bruno were not, even though they may have handled mental health cases before, they had never presented to a jury a diminished capacity evidence, or diminished capacity case. Mr. Bruno hadn't. Mr. Evans says he had done it twice, but one was on PTSD and one was on something else, never in a severe schizophrenia case. And they both admitted they wouldn't know the exact questions to even ask about what else should be done. That's the whole purpose of having psychiatric assistants. And with no due disrespect to psychologists who have PhDs or a professional psychology degree, there's two different types of degrees there, whether you've got a PhD or a doctor of psychology. With no disrespect to them whatsoever, the training between what they do and what a psychiatrist does is very different. And there are some severe mental illnesses that necessarily require a psychiatrist. Severe schizophrenia is one of them. And the defense here was unarmed with even the assistance of a psychiatrist to guide them on, here's what we need to do, here's what we need to look for. You know, he had years of untreated schizophrenia that could impact neurocognitive functioning. We need to take a look at that. We need to see what's going on here. If I was a consulting psychiatrist, it could have told them, if I was treating this patient, I'd want to take a look at that issue to see what was there. But they didn't have those things. And you heard Dr. Akarkar and his testimony, and I asked him that very question. If I had gotten him involved, or defense counsel had gotten him involved, or a reasonable psychiatrist involved at that stage, he says, I would have requested neuropsychological testing. They didn't even know to ask because he didn't have a psychiatrist. And only a psychiatrist can treat schizophrenia. Our second amended motion at page 74 is where we began the discussion concerning ineffective assistance of counsel. As the court's well aware with that standard, deficient performance, counsel's performances fall below prevailing professional norms, standards for defense counsel. Prejudice, reasonable probability of a different result. Cowles versus Whitley says another way to think about that is, has there been an undermining of confidence in the outcome? An undermining of confidence in the outcome. And then, of course, our Tennessee Supreme Court at Kendrick versus State, quoting Williams versus Taylor, in how high of a burden is this reasonable probability? It's a lesser burden of proof than preponderance of the evidence. And it should be, because we want to make certain that before we take the ultimate step of depriving someone of their freedom for the rest of their life, we're taking their life away, that in respect to juries and our jury system, that the jury has the information it needs to make the right decision. And they didn't have that here. Our second amended motion at page 75, and we cite Hellard versus State from the Tennessee Supreme Court. Although when assessing an attorney's performance, it is not this court's function to second-guess tactical and strategic choices pertaining to defense matters or to measure a defense attorney's representation by 20/20 hindsight. Such tactical and strategic choices must be rooted in sound legal basis and adequate pretrial preparation to include necessary factual investigation and legal research. That did not occur here. When counsel's choices are uninformed because of inadequate preparation, a defendant is denied the effective assistance of counsel. That's what happened here. There was no investigation or research here into diminished capacity evidence specifically, but more broadly, no independent investigation into the mental health illnesses here. And both Mr. Bruno and Mr. Evans admitted they didn't even legally research the issue, conduct legal research on some of the other critical things that they were making strategic or tactical decisions about here related to the mental health evidence. One of which is this fear that the state will get an expert. That was the reason. Oh, we've got these experts from Middle Tennessee Mental Health and from Vanderbilt. They never asked them, by the way, if they'd ever testified in front of a jury before. Never asked them. And as the court's aware, you've got the affidavits from those two doctors now. Dr. Eisen had never testified on the issue of mental state and in front of a jury. And so there's not only they were operating under the assumption, defense counsel was, that even if they did their own evaluation, and I respectfully submit to the court, before you even get to the step of an evaluation, they were ineffective just to not get someone to consult to tell them what they may need to do. But then they get to the step of if they had someone consulting and they said, look, we need to do an independent forensic psychiatric exam because it's schizophrenia. It's a mental health disease. It's a medical issue. We need to have a psychiatrist come in and do an independent exam. And then on top of that, there's neuropsychological issues. We need to test brain function. If they had done that and they developed the evidence that you now know would have been developed, and they had noticed it, well, before they even noticed it, they would have been armed then with the information to be able to make that strategic choice, right? They then could said, okay, do we notice it? Do we not notice it? They would have known that, oh my gosh, we now have a more complete legal insanity presentation. And we also have diminished capacity evidence that we can assert. But they were afraid to do so because the state could get an expert. But here's the way the law is on that. And you heard me ask Mr. Bruno and Mr. Evans this specifically yesterday. Did you do any research as to whether or not the state would be able to get their own expert, get another bite at the apple? Automatically in this situation where you've got the entity that has the contract for the state under the statute to do the initial county evaluation, and then you've got the state psychiatric hospital both finding legal insanity. Did you do any research as to whether or not the state gets another bite at the apple there? And the court knows what their answer was. They said no. They operated under the assumption that the state could do that. And here's what the law is in that area. It's discretionary, not a matter of right, with your honor. Rule 12.2c says that the court may allow that evaluation to occur, but then when you bury into the statutes concerning, getting an evaluation done, it's first by who's got the county contract, the county evaluator. Here's the bottom line language. The court can order a further evaluation only if necessary. Only if necessary. And this is after it's already gone through the process of someone's been evaluated by the county evaluator, evaluated by the state hospital. Only then, under the statute, can you order another evaluation only if necessary. So there's the may under 12.2c, the necessary statutorily. And so the way the case law is on this is that if the prior state evaluation is adequate, which means they were able to complete the evaluation of the defendant, then the state didn't get to keep getting bites at the apple. And in the cases where it was an abuse of discretion, the appellate cases of a trial court to do that, those are cases where that state psychiatric hospital evaluation was not able to be completed or was incomplete. One of the main cases on that is also another Husky opinion in the same case. It involved multiple personality disorder, and the state hospital needed to get in a particular type of expert. They couldn't evaluate previously because they didn't have an expert specific to multiple personality disorder. And so the issue was, getting another evaluation done. It wasn't abuse of discretion of the court to allow that, given that they couldn't even complete the evaluation they'd attempted before. They completed the evaluation here. And so whether or not the judge would have allowed them to do that is another thing. I don't know what your ruling would have been on that, Your Honor. However,
Yeah, here's my position on the idea of being afraid to put forward your defenses and this type of thing. If you're scared of your own case, you may want to look at a different approach. I mean, so I have a hard time accepting an explanation. I'm afraid the state would find out and they would try and load a new gun or something. Then you must be concerned about something with your case, and you need to look at it further.
I agree 100%. As obviously, I wasn't qualified as an expert witness to testify on effective assistance of counsel. I've tried mental health cases in front of juries before, and when the state has the ultimate burden of proof, I've tried diminished capacity cases to a jury before. When the state has the ultimate burden of proof, I like a battle of the experts. These doctors can't even agree what was going on with this person. How in the world can you, ladies and gentlemen of the jury, find that they have proven this beyond a reasonable doubt when you have highly trained people that cannot agree? And so I don't find that strategy here to be reasonable on multiple grounds. That ground being one of them. The other ground being they didn't even investigate it. They didn't know what they had or didn't have. And if they were that afraid of their shadow, as the court just said, that should have let them know. They should have evaluated how strong their defense was. So, what did the jury not hear? Of course, the jury did not hear diminished capacity evidence. The jury may have heard about schizophrenia, but they didn't hear about it in the context of the defendant could not form premeditation, the defendant could not form specific intent. And given the jury instruction that the court gave, and you heard me ask these questions of Mr. Bruno and Mr. Evans, if the jury first had to consider whether or not the state had proven all the elements of the charged offenses beyond a reasonable doubt before moving on to insanity, then if diminished capacity evidence had been presented and a diminished capacity instruction asked for, because diminished capacity evidence is not a defense, not an affirmative defense, but some evidence that just helps to negate the state's burden of proof, the jury could have considered that when it was making its decision about guilt or innocence. And so, today the court heard in the colloquy between counsel for the state and Mr. Rabin that there is no clear authority for that instruction that was given. If it was, there's no clear authority that says it was wrong. There's no clear authority that says it was right. If it was right, this would have had a substantial impact.
All the more reason.
All the more reason. Why in the world do you not develop this evidence and attempt to present it? So, and then I already said this before, Judge, there was an incomplete insanity defense presented. The jury did not get to hear evidence of mental defect, did not get to hear evidence of inability to appreciate nature, the cognitive function issue. When you bury down into Tennessee's cases, it talks about appreciate nature as a cognitive function issue. So the type of, when you bear the burden of proof, the type of experts you present, the type of witnesses you present is important. It's critically important. And they had mental health experts who had never testified on mental state at a jury trial. And they didn't have a psychiatrist or a neuropsychologist with decades of experience each. And so there was a weak presentation of the defense when the quantum of proof in the defendant's favor would have been significantly stronger. And they would have heard about severe neurocognitive deficits in addition to severe schizophrenia and the compounding effect of both at the same time. And the court is aware, and I've already mentioned, the jury didn't get a diminished capacity instruction and the ability to consider that when considering mental state. Now, we've raised at page 104 of our motion this issue of newly discovered evidence. Before I get there, let me say this. Obviously, for ineffective assistance of counsel, the court has to find deficient performance on the part of the lawyers and that it mattered, that there was some prejudice, even that the defendant could have gotten convicted of one lesser among the 4 homicides and the 4 attempted homicides. Even if he could have gotten convicted of second degree, that's enough. And to meet reasonable probability of a different result. And that is not a high burden. It's less than preponderance of the evidence. And as the Supreme Court says, it's really, has the confidence in the outcome been undermined in some way? And I respectfully submit to the court, this is one of those cases where I think that is clear. We have an undermining of confidence in the outcome of this case. The state can say whatever it wants to say about what it believes about the weight of the forensic psychiatric and forensic neuropsychological testimony. I would note they still have not presented any counter evidence on this, and that the cross-examination of both Dr. Garkar and Dr. Spica did not go to the heart of their findings. But the court doesn't have to find that the defense ultimately would have prevailed. The court doesn't have to find that legal insanity would have been proven. The court doesn't have to find that Mr. Reinking would not have been convicted. Is there a reasonable probability there would have been a different result? Do we have an undermining of confidence in the outcome here? If the court finds that there was just enough diligence by defense counsel, though, it doesn't mean that's the end of the ballgame. And Rule 33 of the Rules of Criminal Procedure allows for a way for the court to still grant a new trial if there is no constitutional violation. If counsel was minimally effective, the court can still consider the evidence. And it's under newly discovered evidence, as the court's aware. And the standards for it, 1, reasonable diligence has been shown. Well, if counsel was not ineffective, you've already met that problem in reasonable diligence. Number 2, the materiality of the new evidence is apparent. Well, I respectfully submit to the court, of course it's material, and of course it's apparent. And then it is a slightly higher standard, though, than reasonable probability. Now we're at likely. The evidence is likely to change the result if accepted by the jury. I respectfully submit to the court that the totality of the facts and circumstances here, it's strong enough to meet that likely provision in this case. And so the court has before it 2 different avenues by which to consider this evidence. And we briefed this significantly beginning at page 104 of our motion, but obviously the main case in Tennessee, more recent one, State versus Singleton. Singleton was I think a conviction out of Knox County that involved whether or not a truck, delivery truck, was able to be started without keys. And the evidence at trial was that the defendant took the truck and he was able to drive it away without keys. And after trial, it was discovered that the truck does require keys to get turned on. And that was enough to grant a new trial under that standard. State versus Goswick, Taylor, and is an old case from the 40s, which is really where this finds its origination in Tennessee law. I've got that briefed for the court. Courts will grant new trials based on this basis. Judge Sword out of Knox County, who's now at the Court of Criminal Appeals, in a case that our firm had both through our firm and then in my capacity with the Wrongful Convictions Clinic at UT. Judge Sword granted a new trial on the basis of some new geolocation evidence. It was his last thing he did as a trial judge. I think that was back, I'm looking at Ms. Goodwin, I think April of this year when we had that hearing, and he granted that. And so, and Judge Sword used that as a vehicle. He said that he and the state agreed in that case with that finding that it was newly discovered evidence. So I, with the court's permission, Ms. Fuchs is going to argue a couple of additional points on closing arguments and cumulative error. And if the court will allow me a little bit of rebuttal time after the state, since it is our motion.
Sure.
I'm sorry, Aaron, go ahead.
No, go ahead.
No, I was just going to say, for those reasons, this case has already gotten some age on it because of COVID, because of successor counsel and the delay in getting the evaluations done. I don't fault anyone, especially with those things. Those things happen. But now, the evidence is developed that should have been developed years ago by defense counsel. And I respectfully submit to the court is armed with everything it needs factually and legally to be constrained to make the determination that a new trial is warranted here. Though I know this case has been such a hardship on the victims' families, on everyone involved, on the Davidson County community, and there's a reason why the seal of the judiciary in the state of Tennessee says that though the heavens may fall, let justice be done. Let justice be done here. Thank you, Your Honor.
Do me a favor, would you send me a copy of your PowerPoint?
I will, Your Honor.
Any little bit that helps direct me more quickly to certain areas would be.
I will, Your Honor. And it's got the page sites in it to the.
Well, that's one reason I
to the big
wanted
brief.
it, because it,
Yes.
it helps direct me, and it's gonna be time consuming enough as it is trying to get through all the records.
Your Honor, we have and we're in the process of making a flash job for the state, but we have a flash job with all the transcripts that we were gonna, I believe, file as exhibit.
I think it was 11 or 12. 11.
11. So we have that.
Guard that, Jackie.
If you'll give me a moment to give Ms. Fuchs some technical support.
I need technical support.
Oh, boy, I definitely understand that.
There was a reason why I was using those computer analogies with the experts. I like playing with computers. There you go.
Thank you.
You're welcome.
I spent all day yesterday trying to get the printer in the office working, couldn't do it. It kept saying that it had jam in it, and I looked everywhere, couldn't find it. Secretary comes in this morning and says, a little paper might help. Never looked there.
Instead of a severe mental disease, that sounds like a severe mental defect.
Yeah, I've got that for sure when it comes to technology. All right, Ms. Fuchs, you ready?
Yes, Your Honor. Your Honor, I'm here to address the court regarding the closing arguments in this case in two facets. First, as instances of prosecutorial misconduct, and second, in instances of ineffective assistance of counsel. And then finally, to address the court briefly on the cumulative error in this case.
All right.
There's language with which all of us are very, very familiar when we practice in these trial courts. The Court of Appeals has said, notwithstanding such, arguments must be temperate, based on the evidence introduced at trial, relevant to the issues that are being tried, and not otherwise improper under the facts or law. We are mindful that the oft-quoted principle that a prosecutor must be free to present his arguments with logical force or vigor, but while he may strike hard blows, he is not at liberty to strike foul ones. That language in Berger is quoted a lot, and for good reason. The prosecutors have a different role than defense attorneys have and are slightly more limited in the way that they are allowed to advocate. And here, Your Honor, there were instances where the prosecutors moved into impermissible areas of argument. State v. Goltz is where the court finds guidance on the different areas that are deemed improper for the prosecutor to argue in closing arguments. Among those are intentionally misstating evidence or misleading the jury as to the inferences it may draw, expressing personal beliefs or opinions as to the truth or falsity of any testimony or guilt of the defendant, inflaming or attempting to inflame passions or prejudices of the jury, injecting issues broader than guilt or innocence of the accused, and arguing or referring to facts outside the record unless those facts are matters of common knowledge. Your Honor, I would submit that in these closing arguments and rebuttal closing arguments, that the state committed errors in every one of those areas. In the initial closing argument, and Your Honor, I will go ahead and let the court know, I am going into minutia and cherry picking out every individual statement that I believe is improper, because one of the things that the court must consider is the totality of the argument and how pervasive improper arguments were throughout. On page 175 of the trial transcripts, the court heard the prosecutor argue and tell the jury that when it talks about the mental state of the accused at the time, don't get that confused, please, with the insanity aspect. This person is so emotional that they can't form premeditation or be capable of premeditation. The prosecutor told the jury, in referring to Mr. Reinking's mental health, he chose not to do anything about it, but yet choices. Asking the jury to infer that because Mr. Reinking was not currently under mental health evaluation, that he should be held culpable for his schizophrenia. At page 2012, it's not about Travis Reinking. No matter how much they want to spend time talking about his thoughts, his feelings, it's about what he did to them, the lives that he took from them. This isn't about what he feels about it. It's about what he did. That's asking the jury to ignore the mens rea requirements that they are to consider and instead focus solely on the actions that were taken. In essence, completely disregarding a significant portion of the state's burden of proof. On page 2025 of the trial transcripts, the prosecutor in rebuttal argued, "We did put on some evidence because we've taken this case as serious as possible because that's what it demands." Asking the jury to infer that because they put on more proof, they were taking the case more seriously than the defense.
What page was that?
That was on page 2025, Your Honor, of the trial transcripts. And I will put this on a flash drive as well.
Thank you, I was gonna ask you to.
On page 2027, the state said he made sure that he had his gun just in case he needed to kill a couple of cops, I guess. And then later, thankfully, former Officer Caleb Andrews didn't knock on his door. He wouldn't be here to testify. And then on page 2031, maybe that baby bump she was rubbing in her testimony might not be with her. Asking the jury to infer that Mr. Reinking was going to kill all of these other people, which was completely outside of the facts before the jury. Next, Your Honor, in the area of expressing personal beliefs or opinions as to the truth or falsity of any testimony or of the guilt of the defendant, Regarding expert testimony, at page 2016, the prosecutor said, "You heard the testimony from the doctors. 2 of them came in. They gave their statements, and one thing that was very clear is that they didn't give this case the respect that it was due." On page 2019, this is the testimony of not an unbiased person, but an advocate. When she took the stand in this trial, she decided to become his advocate and not an unbiased witness. Perhaps in her other cases, she was not so conflicted. But in this one, for whatever reason, it's clear from the evidence and the testimony that she was. Page 2021. They didn't even care enough to do that. They didn't even care enough to hear the testimony of the eyewitnesses. Uninterested in that. Page 2032. They didn't want to completely walk back their testimony because they signed a report. They didn't want to come across as unprofessional, I guess. All of those were indications of personal beliefs and opinions about expert witnesses before the jury. The jury is the judge of credibility, and the prosecutor is not to make statements reflecting on that the credibility or believability of witnesses. Regarding what Mr. Reinking was thinking in unrelated instances, he made sure that he had his gun just in case he needed to kill a couple of cops, I guess, and that was on page 2027. There were also several statements made that are dismissals of the insanity defense, including on page 1975. And when it talks about the mental state of the accused at the time, don't get that confused, please, with the insanity aspect of it. This is the person who is so emotional that they can't form premeditation, be capable of premeditation. Even if he had been excited at the time when he fired shots that blew Joe Perez's brains out, gunned down Tarian Sanderlin like he was on some hunting expedition, if he was excited, it wouldn't have mattered because he had planned to do it ahead of time. And when it talks about the mental state of the accused at the time, please don't get that confused, please, with the insanity aspect of this. This is the person, oh, I'm sorry, that was an error on my part to put that twice. On page 1980, we can get into all of this psycho testimony about God ordering this and aliens and the things. He has schizophrenia. He has an active imagination. He has a Taylor Swift attraction. Apparently, you have to stand in line from that, from what doctors say. That in and of itself is not unusual. Extremes. But again, that has nothing to do with what he did know, did he know what he was doing when he killed these 4 innocent people and wounded others, put many lives in danger, in jeopardy. And then went so far as to disparage the defense attorneys themselves. The defense said that they have sympathy for these victims. I suppose words are an expression of sympathy, perhaps. But I can't tell that Travis Reinking has any sympathy for these people. Which segues into the next category of inflaming or attempting to inflame passions and prejudices of the jury. Both the closing argument and the rebuttal argument were filled with inflammatory language, asking the jury to make a decision based on emotions rather than law. Throughout the course of both the closing and the rebuttal closing, the word evil was used approximately 29 times. There was also significant references to war-type imagery, battle wounds, carnage, things of that nature. And further, there were several references to the defense asking the jury to hold Mr. Reinking blameless, using that particular word, blameless. On page 1972, and I say that because I can only imagine the survivors, the family, anyone connected with this case having to live with that for the rest of their lives. That statement was made in reference to driving past Waffle Houses, and how the psychological effect of that would remain with everyone in the courtroom, including the jurors. But for James Shaw, the death count certainly would have been higher. Page 1973. But that's where we are in the sense of the criminal law. I submit to you is based upon reviewing facts, applying the law as the judge will give it to you, and making that determination of what is right and wrong. And I submit to you, on behalf of the state of Tennessee, it would be wrong not to convict Travis Reinking of all 16 counts in this indictment. Your Honor, that's a moral imperative to convict. On page 1974, his defense is one that he should be held blameless for his actions. They did not choose to be his victims. On page 1975, like he was on some hunting expedition. Later down, a cold, calculated killer. Page 1976, you saw the catastrophic battle-type wounds, war wounds, suffered by Shantina and Sharita. Page 1976, every morning they wake up, through the day, at night, before going to sleep, if they can sleep, they know they've been disfigured for life. Page 1977, and they will live with it for the rest of their lives. Yes, as I submit perhaps all of us in this courtroom and many watching remotely. Again, putting the jury in the position of being victimized by Travis Reinking. War zone, horrific. The words that, how do you describe something so horrible, much less living through it? Page 1977. But I submit, members of the jury, the one word which ties back to the moral certainty and foundation of criminal law, that this was an evil act, evil. And who described it as that? The man in the blue shirt sitting behind me. He's the one. And what more apt description? He knew it was evil. He committed evil. And that takes us to the defense burden of insanity. Your Honor, I would submit additionally that segue from evil into the defense burden of insanity also goes to a disparagement of the insanity defense. The state then continued on. Then you determine Travis Reinking blameless because he can meet the requirements of the insanity defense in the state of Tennessee, because that law has a high burden. I believe you heard the judge say that it's one example is from the state is taking your child away, under 18 years, child, away from you, terminating your parental rights. One of the most sacred rights we have as parents. Travis Reinking terminated the parental rights of the families of Joe Perez, Tarian Sanderlin, Aquila De Silva, and DeEbony Groves. He terminated their parental rights. It is a high standard. For you to find this man blameless, you have to be convinced, clear and convincing evidence that he had a severe mental disease or defect at this time. Page 1980. And if there is any one thing that says he knew that this was morally wrong, it was evil. What he was doing was evil. Page 1981. You decide whether the carnage he inflicted upon these people, the community, was without any legal blame to assess to anyone. Page 1982. Punishment. We do circle around a little at odds, and it's jumping, but what goes through and what was going through Travis Reinking's mind was evil. Page 1982. Some other words I believed he used, he felt it was foreboding, sickening, unholy. Page 1985. But on this occasion, at the time of the commission of these evil acts, He made the choice after reflecting upon it and weighing, I submit, the possibilities. This was no command delusion, no alien delusion, because if it was, he would not, I submit, have had any second thoughts. He would not have had any internal discussions about it being evil or sickening. Page 1987 to 88. But no, he chose a human hunting weapon, a semi-automatic assault rifle loaded with a magazine containing 30 of these, 30 exploding human-killing bullets. Each one of these, I submit, ladies and gentlemen, could represent another dead human being, but for James Shaw Jr. Page 1988. That was a choice Travis Reinking did not get, to continue his carnage of shooting and shooting. I submit we all have choices between right and wrong, good or evil, moral or immoral. 1989. He is not legally blameless for these actions that destroyed so many lives. Page 2011 through 2012. Ladies and gentlemen of this jury, I'm not going to do like the defense and wait an hour and 15 minutes to mention the victims of this horrible, horrific massacre. Page 2012. It's not about Travis Reinking, no matter how much they want to spend time talking about his thoughts, his feelings. It's about what he did to them, the lives he took from them. Page 2012. These are people who loved and were loved back. This isn't about what he feels about it. It's about what he did. Page 2013. He's conflicted because he knows it's evil. He knows it's unholy. He knows it's unclean. Page 2014. No sympathy has he given to these families. No remorse. None. Page 2014. This is a man who, on April 22nd, 2018, took so much. He took so much from them. He robbed Joe Perez Sr. of ever meeting Joe Perez III, robbed the Groves family of ever hearing DeEbony sing Jesus Loves Me ever again, the last time she sang it as she was there in that booth at the Waffle House, robbed Beatty of being able to truly enjoy the celebration of the music video that he had just made with his little brother that same day, robbed Tarian Sanderlin of ever achieving his dream of becoming a chef or cooking Thanksgiving dinner again with his aunt and the rest of the family. Page 2015. We spent one day talking about the victims and what he did. The rest of the time we've spent talking about him, and that's unfair. It's not right. Page 2016. That's malice. That's somebody who knows what they're doing. Just a malicious person, vicious person, evil person. And one thing that was very clear is that they didn't give the case the respect that it was due. Page 2019. Describing your actions as evil, it can be. Now, you, ladies and gentlemen of this jury, know that evil is as wrong as can be. Page 2022. Injuries consistent with having been in a military battle. Page 2023. He thinks he is smarter than you. He believes he knows better than you. And that was directed towards the jury. Page 2025. This is a man who is evil. This man who is evil, he knew what he was doing. He knew it was evil. Page 2026. And of course, because he thinks he's smarter than he is, that he's smarter than you, smarter than these doctors. And maybe he outsmarted them in this particular instance because he thinks he's smarter than you. He thought that he was going to get away with it. Page 2027. He made sure he had his gun just in case he needed to kill a couple of cops, I guess. Page 2031. Thankfully she did. Otherwise, who knows what could have happened. Maybe that baby bump she was rubbing in her testimony might not be with her. Page 2032. Defense said they have sympathy for the victims. I suppose words are an expression of sympathy, perhaps, but I can't tell that Travis Reinking has any sympathy for these people. Page 2035. He's making an assessment about the value of his life, one that he didn't make about the value of lives of these wonderful young people who were killed. Page 2036. He knew when he could act in a way where he could just be the murderous man that he wanted to be. Page 2036. Ladies and gentlemen of this jury, as I mentioned to you earlier, you took an oath to be fair, to be just, to do what is right. 2037. Any other verdict would be as wrong as Travis Reinking was on April 22nd, 2018. Counsel for the state utilized epithets characterizing the defendant as evil, malicious, vicious, murderous, and more, using military's type violent language to describe these horrendous events in such a way as to inflame the jury and to encourage them to make their decisions based on the horrendous nature of the offense, rather than giving due consideration to the mens rea and the insanity defense as it was presented to them. Telling them that they had a moral obligation, that the right thing to do, the good thing to do, would be to convict Travis Reinking, because Travis Reinking is wrong. Travis Reinking is evil. Putting them in that dichotomy of good and evil, and even putting them in that position to where it's a moral imperative that they convict. Making disparaging comments about expert witnesses, the defense as a whole, and defense attorneys. Asking the jury to hold those things against them because the defense and the defense experts didn't give the case the respect that it was due. Didn't put on as much proof as the states had. They attempted to cast the jury in a light of being a victim of Travis Reinking's because of having to be through this trial and because of him having this conniving mentality of believing that he's smarter than them, that he's trying to outsmart them, and that if they find him not guilty by reason of insanity, then they have let him outsmart them, just like he outsmarted these doctors. The issues regarding injecting issues broader than the guilt or innocence of the accused. On page 1978, then you determine is Travis Reinking blameless because he can meet the requirements of the insanity defense. In the state of Tennessee, because that law has a high burden. I believe you heard the judge say, one of the examples is from the state taking away your child under 18. This is that quote I mentioned earlier regarding the parental rights outside the scope of what was before the jury and broader than what was encompassed by the guilt or innocence of Mr. Reinking. Again, there was also, as I noted in the personal belief and inflammatory language section, the call to avenge the community on page 1981. Injecting the issues of, on page 2014, all of the things that the families and the victims were missing because of these actions. Arguing or referencing facts outside of the record also included the fact that there was this punishment level from having to sit through the trial that was mentioned from page 1977. The references to killing police officers, the references to killing the potentially unborn baby of one of the witnesses. In addition to those deviations into the 5 factors prohibited by Goltz, there was also a violation of the missing witness rule. During the rebuttal closing, the state argued that the defense had only presented 2 witnesses, 2 expert witnesses, and one of them being from MTMHI, but there were other doctors that had been at MTMHI that were not called, including Dr. Fikes and Dr. Kovach. That statement occurred on the record, trial transcripts page 2019 to 2020, when the prosecutor specifically had said that they didn't hear from Dr. Fikes or Dr. Kovac, and that they could have easily come if they were going to provide valuable testimony. And he said, where was he specifically calling them out for not calling those witnesses?
Let me ask you something. Did the defense attorneys in opening statement say anything about having additional doctors testify?
I don't believe so. I don't.
So this wasn't in response to something that the attorneys said they were gonna do and didn't do?
I don't believe so. I would have to refresh my memory on the opening, but I do not recall that as being an issue that was addressed.
Okay. I mean, I'll flesh that out, but oftentimes that's how things like this come up. That's why I was asking.
There are certain considerations that have to be met before counsel would be allowed to make those types of arguments. Among those being that the witness has knowledge of material facts, which I do believe is present here. There were records to indicate other mental health experts involved. But there was also the factors of a relationship exists between the witness and the party that would naturally incline the witness to favor the party. Mr. Rabin actually addressed that in his testimony, that these state doctors do not have that type of relationship, and further that the missing witness was available to the process of the court for trial. That was also not established. Your Honor, there was the suggestion that because Mr. Reinking did not testify, that he was not showing the family sympathy or remorse. And that occurred on page 2014 and on 2032, which is impermissible, an impermissible area for the state to go into during their closing arguments. When the court is looking at all of these arguments, if they find that the arguments were improper, they then must look to whether the improper conduct could have affected the verdict to the prejudice of the defendant. And there are 5 factors that the court is to look at. The facts and circumstances of the case. Your Honor, this was a horrendous set of facts, absolutely devastating to everyone involved. The facts alone are very inflammatory. That should have triggered the need for extra caution. You don't need to pile on with facts like this. Any curative measures undertaken by the court or by the prosecutor. Your Honor, unfortunately, Mr. Bruno said he's not one that objects during closing arguments. And so there were no objections to any of these statements made. And so there were no curative measures taken. Now, the court could have sua sponte given an instruction, but that was not done either. The intent of the prosecution, Your Honor, I think the intent was clear to cast this man, this very sick man, as instead of being very sick, as being evil. And I'm sure that there are a lot of people in this courtroom that believe that he is. But that's an improper argument to make to the jury. He is severely schizophrenic. He is severely schizophrenic. And his primary delusions regarding this, he did not know or appreciate his actions at the time because of how severely sick he is. The cumulative effect of the improper conduct and any other errors in the record. Your Honor, again, this is why I made the point to go through for any appellate record, if that becomes necessary, to quote every single thing that we are objecting to, because it was so pervasive throughout both arguments. It was rare that I skipped many pages. Just the sheer pervasiveness of those arguments throughout the closing arguments made it that much more prejudicial, especially with then no curative effects on top of it. And then combining that with the other issues that are present in the case that we have discussed, and the relative strength or weakness of the case. Again, this was a case that did revolve around the mind of Travis Reinking. This is something to where That was the primary focus. This was not an effort to disregard or not take into consideration his actions, but it was to consider everything that is before the jury, not just the actions, but also the mental health evidence, in order to determine mens rea. And there was unrebutted expert testimony that Mr. Reinking was suffering from a severe mental disease or defect at the time, and that he was unable to appreciate the wrongfulness of his conduct. In asking the jury to make these decisions on emotional bases rather than on legal ones, it's asking the jury to discount his mental illness, which I believe the jury did submit a question regarding how they're supposed to look at wrongfulness as it pertains to a mentally ill person. And Your Honor, I would submit that the arguments made by the state in this case were entirely intemperate as a whole and so inflammatory that this could not be deemed a harmless error. That these arguments were so inappropriate and designed to inflame that it effectively, it took the ability of Mr. Reinking to have a fair trial away. It was allowing the jury to embrace the outrage and the pain that was involved in this case and make their decisions on that rather than on the law. Cumulative error. Your Honor, I know Your Honor heard all of the proof at trial. You have been provided an enormous amount of material at the motion for new trial. And so I'm going to try to stay very 30,000 feet in the air on this. The cumulative error doctrine is a judicial recognition that there may be multiple errors committed in a trial proceeding, each of which in isolation constitutes mere harmless error, but which when aggregated have the cumulative effect on the proceedings so great as to require reversal in order to preserve a defendant's right to a fair trial. Here, Your Honor, we had issues of ineffective assistance of counsel, newly discovered evidence, prosecutorial misconduct, issues with some of the court rulings, and insufficiency of the evidence. And Your Honor, we have presented extensive proof, particularly regarding the ineffective assistance of counsel and that newly discovered evidence. These issues, even if not sufficient standing alone, when they are combined, require a new trial. Given the pervasive nature and the interrelationship of these errors, the weakness of the admissible evidence presented by the state regarding Mr. Reinking's mental state, the newly discovered evidence, and the instances of ineffective assistance of counsel, the cumulative errors in this case deprived Mr. Reinking of his right to a fair trial. The individual strings of these issues may not on their own be strong enough, but when Your Honor braids them all together and looks at them as a whole, they make a rope. And that rope in this case pulled down so far on the scales of justice that this trial was not a fair trial for Mr. Reinking. And at the end of the day, there is not confidence in the jury that was rendered by the verdict because of all of these issues. Your Honor, we appreciate the court's time on all of this. We would ask the court to grant the motion for new trial in this case.
Thank you, Ms. Pugh.
Do I just want to okay? Just like.
Can we have just a comfort break? Thank you.
Come back about 10 minutes.
so much. Thank you, I liked it. Did you get it right? Close.
Did you throw in an E? I get a lot of E's out of it.
I think I did. I would have Googled and checked, but I'm quite different.
Well, I know better and I meant to do it and I just started and
Well, I've had a lot going on.
It's like you, and you take them out.
I'm having the last thing, drop, you know, motion. Other than motion. I should have put one out there.
Right.
Yes, exactly.
I'm surprised it's not a picture of your driver. It's just a picture of you is what they're asking.
They do want a picture of my dog.
Oh, what they give you?
Just, I guess they recognize who I am.
I hope the judge makes this decision.
Yeah, he said, until it makes a decision. Tony says another break, and I'm like, yeah, we can meet. Yeah, they really haven't taken any breaks.
I am. I'm just trying to. Wait, you don't need two up there though. Which one?
One's his, one's mine.
I know, but he already has one.
Oh, okay.
So which one is yours?
This is not
Then take that away.
you have too much?
Now he had one on the witness stand. He was one on the judge. He's always had one above the judge. Slack on this
That's all good.
one. Okay. That's all you'll get. I know, yeah, you already had one, Judge.
It takes forever to film that, so.
But your place is gone. I didn't see it.
Good shot.
All right.
Be seated. All right, who's gonna argue?
Judge, if it's all right with the court, I'll address Ms. Fuchs' portion, and then Gerald Dowdy will address Mr. Johnson's.
All right.
And I will be hopefully quite brief, because there's no way I could remember each one of the minutiae that she went through, but I assume that will be on a thumb drive that we'll have available, and the state may go back and look at each one of those. But I would submit respectfully, on behalf of the state, the reason there were no objections to those comments is because they were not objectionable. These were not foul blows. Each comment that she picked, and again, I know the court will review the entire arguments so that they will be in context, but I submit that the comments, the arguments were based upon evidence that had been presented during the trial, and for, like, one of the arguments or sections was based upon, as Your Honor had told the jury in explaining clear and convincing evidence during jury selection, I believe, gave the example of termination of parental rights as being, and then describing reasonable doubt as being higher than that, but clear and convincing is what the state has to do take your child away from you. So that was based upon argument that, yes, she had a child. This is just all of everything that was argued and picked out in this was I think I'll use the word minutiae, but cherry picked. And let's start with evil. I didn't count. I think I may go back and count how many times that word was used. It was used a lot, but who was it first used by? Travis Reinking in his journals. He's the one who said he was evil. And that's where these comments and the arguments about, no, he had no remorse. If you ever recall the journal entries, those were in evidence before the jury. So every comment that used that word was a reflection based upon evidence that was in the record, as were all of the comments. He wrote the journal. He left it and gave his explanation, if it were, for killing the people and about how he felt and what he had done. The journal entries, no remorse. I would submit that the comments, and again, going through these, trying from memory, about Dr. Eisen, I believe her testimony was, I'm not quoting verbatim because I don't have it, but was that, I don't know what the word she said was, she liked Mr. Reinking, but there was a appearance before the jury that certainly the state wanted to bring out, that she had sympathy for him, that she was not as impartial a witness as she might have appeared to be. The witness testimony, Dr. Eisen, as I recall, in her testimony about the MTMHI team, referenced Dr. Kovach numerous times, as I recall. But again, the transcript obviously is the record, and whatever it says is correct. But what's meant under that, I believe also, as Your Honor might have recalled, that counsel, either in opening, someone did reference having three, they were going to present three doctors. But the comment about that was based upon testimony from Dr. Eisen, comments from the defense, and was not a violation of the missing witness rule, because, for among other things, as counsel pointed, the witness as a court witness would not necessarily be expected to favor one side or the other. Now, obviously, as the proof came out through cross-examination, we certainly disagreed with that lack of objectivity from what we saw in this, but in any event, the arguments that were made by the state, I don't say, there may have been a time or two where someone said, I submit, or I guess, that, you know, strictly adhering to the state submits as using that verbiage, but those random isolated comments could not in any way ever be rationally considered to be that a personal statement of belief as condemned by various opinions, and that would have been improper conduct. There was no prosecutorial misconduct in this case whatsoever. Every argument, and the comment about killing other people. He would have, but for James Shaw Jr., we know that. The court knows that from the proof. That was what stopped this rampage, not anything else. And again, the evil aspect was using the defendant's own words. And I take issue with saying that the state asked the jury to convict on some sense of outrage to the community, or anything like that. That was not any argument that court could reasonably see as going that direction. It was based upon the evidence. And yes, I do recall, it's like part of it was the Waffle House. That was a location. And the fact this was such a horrific crime that, yes, and I've tried cases, I think we probably all have, where, we could expect the jury to have some, never forget the case that they have sat on. Never forget this. And there's nothing wrong with that whatsoever. It was a serious case. It's the most serious that I can recall in Davidson County in 20, 30, 40 years probably. So to minimize the severity of his conduct would have been malpractice by the prosecutors. We did argue this case strenuously based upon the evidence, but not outside the bounds. And as I said, that's why there were no objections, I submit. It's because there was nothing objectionable about it when Your Honor looks at it, everything in context of the opening and the closing argument in the guilt-innocence phase. The arguments were temperate under the circumstances, I would submit. The state could have, no one cried or pounded on the furniture or did anything to demonstrate other than what the facts were. And yes, what Mr. Reinking would have done, but for James Shaw Jr. and how many bullets he still had left. I think that was a very effective. But was it outside the bounds of argument? Of course not. No, it was based upon the evidence. The evidence, the bullets themselves were in evidence as exhibits. And counsel, either side, are entitled to use the exhibits that have been introduced. So the comments about that were based upon, again, the evidence and the facts that were in the case at that time. Again, I apologize for not being able to recall every single one that she put up, but separately or in combination, if Your Honor finds that any one statement was objectionable, I would ask the court to put it in the context. And by that I mean if the court looks at one of these on the thumb drive and going back and reviewing this, well, that statement, ask the court, look at what was said before, after, and what the evidence was. Because this was a fact-based case. And yes, the state, Smith, had every right to comment upon the evidence that was introduced. We did not go outside that, anything whatsoever, and I would submit that there is nothing that the court could find that this was violation of the defendant's right to a trial, fair trial, nor were there any cumulative errors. If you look at that aspect, again, Cheryl Dowdy will talk about or respond to the ineffective assistance. But everything that occurred in this case, submit Your Honor, ruled correctly based upon the law and the evidence. And if anything, Mr. Reinking was given the benefit of having more evidence introduced and more leeway, particularly about the videos. Your Honor allowed some in over the state's objection, as I recall. But these were comments and arguments based upon evidence, not anything else. And the cumulative error argument fails because there was no error in this case. And I'll defer to Cheryl Dowdy and ask the court again to review the transcript.
one moment and have this string come up, please. So we'll have some.
You want the DVD or the PowerPoint?
The PowerPoint. Your Honor, while General Moore was speaking, I was able to go back through some of those transcripts and find just a couple pieces of the transcript that directly contradict defense counsel's statements about the suggestion that the state had been improper in some of its argument. And so I'm going to go all the way through if I can.
So you're addressing the arguments?
Yes,
Oh, okay.
just briefly. Just a couple examples here, so if I get all the way to my end of my inflection. So there was a defense counsel suggested that it was improper for us to mention the word evil. As the court knows, Travis Reinking introduced the term evil. It didn't just come into the trial, it came in because that's how he described it. This is from the Mental Health Institute Forensic Staff Conference Note from July 26, 18. Forgive me on the date. I'm trying to edit this slide just a few minutes ago. Page 6, this is already in evidence, Your Honor, and was reviewed by both Dr. Agarkar and Dr. Spica. What he says is, then I remember just feeling like I was going to throw up because I was like, this is something that God told me to do, but it seems evil. Those are his words, not ours. In the trial testimony of Dr. Rena Eisen, question. He then reported that he shot at the man with the number 3 head. I think I missed at first, and then I had to fire again the second time. That one hit him, and he fell to the ground. Then I remember just feeling like I was going to throw up because I was like, this is something that God told me to do, but it seems evil. It seems foreboding. That's what he reported to you. Answer, yes. It was in the trial. We didn't describe it as evil, he did. Again, from the trial transcript from page 1848, and Mr. Reinking's statement to you was that he believed what he was doing was evil, correct? He said it seemed evil. I believe, yes. It seemed to him to be evil. Answer, correct. This is not prosecutorial misconduct. These are the words of a man who is describing his own actions. We were recounting the evidence to the jury. One other thing, and obviously I was not able to respond to everything in just a few minutes. There was questions about comments about Dr. Kovac not showing up. The question of Dr. Kovac and whether or not he could come in and testify fully consistent with the testimony of Dr. Eisen in particular was an issue in the trial. And the defense counsel continuously tried to make it appear as if he had in no way any disagreement. And we posed a question to Dr. Eisen about that. about the fact that Dr. Kovacs, in a progress note which was contained as part of the reports that ultimately went to Dr. Eisen's opinion, said that Mr. Reinking's mental state at the time of the charges is looking more and more like he had an appreciation of the wrongfulness of his criminal actions, but was acting out of revenge. And there was not a compelling basis for his lack of appreciation of the wrongfulness, as he has been consistent in regard to hearing the voice, to knowing the alleged crimes were wrong, but that God told him to do it, to it being thoughts in his imagination telling him to commit the violent acts. You reviewed that correct. Dr. Eisen responded, correct. So, Your Honor, it was proper to discuss whether Dr. Kovacs, and this is important, and I'm kind of skipped ahead of where my argument was going to begin a few minutes ago, because a large part of what defense is asking you to do here is both to ignore the evidence and the reality of the circumstances of what was going on in this case. There's a suggestion that there was a failure on behalf of Paul Bruno and Luke Evans because they did not consult with or hire another expert. The reality is, however, they had two experts ordered by the court who they deemed to be credible and respected, not just on their own assessment, but within the state of Tennessee and our community larger, in this field of clinical psychology. They said that Dr. Eisen was extremely confident in her opinion. What you heard Mr. Bruno say was that Dr. Wood was confident, but she appeared to be a little less confident. And the central question of whether or not they should hire another or seek consultation from another expert centered around not only the evidence and the proof, but what would happen if they hired another expert. What you heard both of them say is, Mr. Evans, we did not want a professional witness. They wanted someone who could come across as unbiased, someone whose credibility and reputation could not be questioned because they had been paid to show up and testify on behalf of Travis Reinking.
Let me ask you this though, that thought process, if we carried that out on a routine basis, experts would never be called. That doesn't make, to me, that is, every expert, just about, except those who work for MTMHI, are subject to that challenge. If that was going to be a motivating factor not to get another expert, then no other experts would ever be called upon.
And Your Honor, if I can respond to that. What I believe both Mr. Bruno and Mr. Evans suggested, and I forget which one said it this way, is that if they hired an expert, one thing Mr. Bruno said was that if they got another report that said Travis Reinking, it wasn't so clear that he was insane. Now we've got 3 reports, and the problem is this isn't a battle of the experts like Mr. Johnson suggested, where you want the battle of the experts, because under Tennessee law, the burden of insanity is to be proven by the defendant. The battle of the experts doesn't help the defense in this particular instance.
But it does on diminished capacity.
Well, that's a different.
I understand we're talking insanity.
On insanity right now. Battle of the experts does not help them. Mr. Bruno discussed when he was talking about low IQs, and I forget exactly what the scenario he was saying. But he was saying if you have an IQ under 70 and you have 2 that are low, but then you have a third, then that presumption becomes difficult and you have a battle over it.
But let's say they get a third expert,
Yes.
And that expert disagrees with Dr. Wood and disagrees with Dr. Ison. And they said, yeah, he's got schizophrenia, but, I'm not so sure I can support insanity in this case. Well, they just don't use him.
Your Honor,
They're not required to turn that over unless they use it.
Mr. Evans told you that is not, that sounds good in theory, but not in practice. One of the things that the state did when we went and met with Mr. Bruno and Mr. Evans in preparation for this hearing is we showed up with a list of all the times that anybody went to go and meet with Travis Reinking. That's how they knew how many times they had gone, right? We knew who went to see him, when they went to see him, how long they went to see him, period. You're well acquainted with my co-counsel here, General Norman, General Moore. These are not people who are going to leave any stone unturned, especially not in this case,
I agree with that.
We were well prepared, and we were going to fight with every tool that we had in our tool belt that was allowed under the law, right? And the point is that Dr. Kovacs is suggesting in those notes that he isn't sure that insanity defense is supported. So it's already a question. When they have the opportunity to look at that, there is a question. If they get another expert, even if they can get that expert to say it, now the state, what I believe Mr. Evans said, they didn't want the state to get an expert that we could hand pick. Not that we were going to force them to say something different, but an expert that we could hand pick. They didn't want that to happen. They didn't want the battle of the experts. They didn't want the state to have its own chosen expert, and they didn't want it to be out there that there was the possibility that another expert in this field would say that Travis Reinking was not insane. And so the best decision, their measured strategy and choice was to go with the two experts who everyone said that they could respect and trust within the field here in Tennessee. That was their choice. That was their decision based on all of the facts and the evidence and all of their experience, understanding the law, trying these cases, handling these cases before they get to a jury, trying them before a jury, doing all of those trainings that they talked about and everything else, Your Honor. So their Dr. Kovacs, the fact that they brought that up kind of changed my argument a little bit, but I think it's very important that you understand that that was an issue in the case, and it is an issue that relates to their decision, their strategic decision to forego trying to hire another expert. Even if the court were to consider their decision to not hire an expert as potentially ineffective, which the state submits, it is not, because they had two opinions already. Forgive me for moving, I know I spoke for a minute, but I do want to go back to the top, because I'd like to remind the court and make sure that the record is clear here now that the entire trial, all of the transcripts of this, what happened have been moved in. On April 22nd, 2018, Travis Reinking drove to that Waffle House on Murfreesboro Road. At the time, the evidence showed that he was armed and he was angry. That's what we argued, and that's what the proof we believe showed. He wanted revenge. It's something he talked about. He wanted to punish people by taking something that they couldn't take back, some of their own lives. That's essentially a quote from his own writings. What was put before the jury is that there were many people at that Waffle House, many more than the victims that were listed in the indictment. They were innocent, but they weren't just that. They were working. They were there enjoying their lives. Torian Sutherland was working. Joe Perez Jr. had stopped to seek refuge because of an issue with his vehicle. And then you had the other victims and live victims in this case, the testimony you heard about Aquila da Silva and Shantia Wagner and Sharita Henderson and D'Ebony Groves, just there to enjoy life. That was some of the evidence that the jury heard about. Since that date, some 6.5 years ago, everything that has happened in this courthouse has been about Travis Reinking. Everything that has happened this week has been about him and not about them. And Your
Well,
Honor,
isn't that because we're having to follow the law?
of course,
I mean, there's nothing that I know of in post-conviction relief that says we consider what happened to the victims. And I don't mean that coldly, but I'm just going by the law. I cannot rule on this case based on emotion.
and I'm not asking you to. I'm asking you to.
But you're asking me to put them first and foremost.
No, Your Honor, I'm making an observation. I'm not making a request. Not in that statement. I didn't say you must put them first. I am saying
You're
as an
implying that we're ignoring what happened to them.
no, Your Honor, I'm making an observation. An observation that this entire process has been about him. I understand that that is the way that our court system is structured, but it is a reality and one that they have to deal with, as they've said here, as you are well aware, during the entirety of this week.
And I don't discount that at all.
Your Honor, I'll move to the standard of ineffective assistance of counsel, which requires that in the absence of proof that the attorney acted outside of the range of professional competent assistance and that the defendant, as a result, was prejudiced to the extent that the result of the proceedings would have been different, the defendant will have been found to have competent counsel. That's the standard that we're operating under. One of the main things that has been argued here and before the court is about diminished capacity or lack of capacity, right? And what we heard from multiple witnesses is that there was significant evidence of premeditation. Significant. You heard that from Mr. Evans, you heard that from Mr. Bruno, and when you heard Mr. Rabin testify, he said that there was significant evidence of intent. He said that over and again. And therefore, most importantly then, diminished capacity wasn't even a defense that was actually available to Mr. Bruno and Mr. Evans.
Why?
Because, Your Honor, the evidence was overwhelming of his ability to form premeditation and to form the specific intent to commit this crime. I mean, that's what the witnesses that they've called here in this hearing have said. Mr. Rabin was classified by the court as an expert in criminal law. That's what he said, that there was intent and premeditation in this case.
Well, no, he didn't say that about premeditation. Yeah, I agree that he said there was a significant evidence about intent. But he said there was a big question about his ability to reflect and exercise judgment.
And Your Honor, if I could go to premeditation, I'm gonna show you a couple things here, all right? From some of the testimony that the jury heard regarding premeditation, because it was put before the jury. They did hear it, they considered it, and they made their decision. From the testimony of Dr. Rena Eisen, page 1862 of the trial transcript, there was a question. This is after the fact. I'm sorry, forgive me. I'd like to walk through a summary of some of the other trial testimony. But this is after the fact here, what you're looking at, regarding Travis Reinking explaining why he took that jacket and those magazines. That goes to premeditation, right? The fact that he put a jacket on and put magazine in there, and then once he's done with the crime, he no longer needs the jacket because he only had the jacket to carry the magazines. That's skipping ahead, but that's exactly a significant point of premeditation that we would argue. There was much more. The evidence.
I'll give you that there was a lot of evidence that could be reasonably argued as clear indication of premeditation and intent, okay? I think there's a lot of evidence in the record that supports that. But that's not, they're not arguing that that didn't exist, they're arguing that nothing was done to counter it.
Well, Your Honor, they had Dr. Wood and Dr. Eisen talk about.
But they didn't talk to him about it from the standpoint of diminished capacity, only within the context of insanity.
Okay, but Mr. Evans told you that he has tried two, not one, but two diminished capacity cases to a jury. Both times the jury rejected his argument, and both times his defendant suffered from a severe mental illness. And what he said
So does that mean you just give up trying?
No, what he said, Your Honor, was that he spoke to jurors. He said this in the court. He spoke to jurors, and they told him that that was not a good defense. They didn't like it. This is a experienced trial attorney who has to take a case, look at the facts, the evidence, the law before him, and also his experiences presenting cases before a jury and decide in his estimation, his strategy, what is the best defense to put
But how do
forward.
you make that estimation if you haven't investigated all the possible avenues available to you?
But he said that he considered it, he thought about it, and because the evidence was so overwhelming as to premeditation and as to intent, he didn't think it would work. In his strategy, after giving it consideration, the proper consideration, that's what he said in his hearing.
I didn't hear him testify that they spent any time discussing.
He didn't say that
capacity.
he didn't say that they discussed it. He said that he thought about it. I guess, Your Honor, if an attorney tries a case by himself, the fact that is he not allowed to think it through? I mean, he has to. The fact that these attorneys could come to their own independent conclusions based on their experience, their knowledge of the law, their training, and that Mr. Evans could come to that conclusion means that he thought it through. There was no reason for him to come and say
But he thought
that.
it through based on what information did he have to think it through?
He had all of the information that he got from the state. All of the information that he got from Middle Tennessee Mental Health
But
Institute.
nothing in the context of diminished capacity.
Your Honor, but the point is that diminished capacity was in his mind was not a good defense because he didn't want to water it down. His words. He didn't want to water it down. They believed that the best defense to put forward to that jury was to ask for an insanity defense because when they spoke to Dr. Eisen, an expert witness who, although she had never testified before a jury, had testified according to her trial testimony 50 times as an expert and been qualified as an expert in many different courts around the state, told them with great confidence, this is if there was ever an insanity case, this is it. It wasn't a close call. And when they spoke to Dr. Wood, someone who they gave great respect to, she said, this is an insanity case. And so when they took that and they said that they met with them multiple times over the course, one of the things that you see when you look at Dr. Wood's affidavit that was submitted by defense counsel for this hearing, what she says is they met with her after they took over the case, which I suggests that they started meeting with her pretty quickly, right? And they did so throughout. Now, what does it mean to consult? I don't know what Dr. Wood would say in terms of consult, how she changes her consultation as opposed in this case as she would in others. She's not here to testify to that fact, so we don't actually know what she might say. What Mr. Bruno and Mr. Evans said is that they met with them multiple times and they talked through the case. They talked through the evidence. and they made sure that they understood the basis of her opinion and how confident they were in it. That, to me, is the same as consultation, right? Sure, they didn't pay her for that opinion, but they're meeting with her and talking to her through those opinions so that they can understand their case, understand what the evidence is, and understand what is the best defense.
When they got onto the case and they already had brought to them on a silver platter the insanity defense, did they end up getting tunnel vision? Because in all the conversations they had with Dr. Wood and Dr. Eisen, stayed strictly limited and focused on insanity. They didn't say, is there anything else you can offer? What else might there be? Anything.
Your Honor, sometimes there isn't anything else, and this is one of those
You'll know
cases.
if you don't ask.
But if there is,
Does not both the jury charge on diminished capacity and insanity require evidence, competent evidence of a mental disease or defect in the first and serious in the second?
it does, Your Honor, and Mr. Evans told this court, testified under oath, that he considered diminished capacity in this specific case, and he has tried 2 of those cases to a jury. 2. Okay, and he said it was his experience, his knowledge, his understanding that insanity in this case was the best and perhaps the only defense that could be put forward in this case. Based on all of the evidence and all of his understanding of the law after his investigation of the evidence that was presented forward. That's what he said. He didn't say, I never even thought about diminished capacity.
Let me ask you this.
Yes.
When you talk about their investigation, what investigation did they do beyond what was given to them when they got on the case?
Your Honor, they hired a mitigation specialist.
Already on board.
But that person continued to work for them. Continued. Like, they brought on another person, Kurt Haskell, questioned some of his things if you want, but Kurt Haskell went and did all kinds of investigation regarding this case. Might not be what you and I would ask someone to do, but it is what he did, and it assisted their understanding of the case.
That's one thing I find interesting. They allowed one of their attorneys to pursue conspiracy theories of the CIA, but they didn't pursue expansion of the defendant's mental state.
What you said, one of their attorneys, and I think
Mr. Haskell wasn't even the conspiracy theorist
what
based on Mr. Bruno.
the distinction I want to make is that he wasn't one of their attorneys. He was one of Mr. Reinking's attorneys.
No, one of the attorneys. You're right.
Mr.
That's
Reinking
correct.
had the right and the ability to direct his counsel in that regard, and that is what Mr. Reinking obviously asked of him to do.
I object to that. There's no evidence that Mr. Reinking was ever conferred about concerning that or directed that whatsoever.
Yeah, I agree with that.
I've been reluctant to object to a lot of misstatements, but I've got to vigorously object to
I
it.
think that was
That's
more
not
Mr.
correct.
That was
That's
more
not
Mr.
correct.
Haskell himself. He came in with the conspiracy theory ideas.
Nonetheless, he was hired by, he was counsel for Mr. Reinking.
Absolutely.
He was not operating at the direction of Paul Bruno or Luke Evans, and that should be very clear.
I object about whose direction he was operating under. The testimony was that he was part of the defense team. He was given a particular assignment because that's the theory that he wanted to espouse, and that's all that we can really glean from the record here in the testimony. And to try to, once again, say that somehow Mr. Reinking was directing him is not supported by the record and improper.
Yes. And Your Honor, I do have a couple slides that I want to show you regarding diminished capacity and our argument regarding it. But what I'll say is that Travis Reinking had a lot of conversation with the doctors at Middle Tennessee Mental Health Institute. Those are documented in progress reports. There are hundreds and hundreds of notes, pages and pages. That is why diminished capacity was not a viable defense in this case because of his own words to to the clinical team, 2 psychiatrists who worked on that team, Dr. Kovacs, a psychologist, Dr. Eisen, a psychologist, a nurse, and I believe a social worker, all trained in this area. You can't, it's easy to Monday morning quarterback this and look at it and cherry pick things. Paul Bruno and Luke Evans told you that when you look at the entirety of this situation, diminished capacity wasn't a viable defense. Now, if I can go to, I think you only want me to address diminished capacity.
No, you can address it all, but I just had questions about that.
Okay. Because one of the things is what was put before the jury, because with regard to the prong of how it would, could it change the
There's 2
outcome of this
reasons
case?
I have interest in the diminished capacity.
Yes, Your Honor.
There's 2 factors, I think, that come into play, is that new evidence has been presented that could reasonably support pursuing diminished capacity based on the 2 additional experts. And secondly, the way that the insanity, and this has been pounded on as well, the way that the insanity instruction was that they couldn't get to that until they first found him guilty, seemed to tell the jury, you can't consider his mental state as to all his delusions and everything until you first find that he's committed the crime, and then you can decide if that crime was in any way the result of his delusions. Whereas mental capacity, it's part and parcel of what they have to consider.
And
So, I mean, because of the way that instruction was written, the mental capacity gets them around the problem of the jury supposedly not paying attention to his mental state. And that's the reason, the interplay of those things, I'm not ruling on it by any stretch of the imagination,
I
but
understand.
it is something that has caught the court's attention.
Well, Your Honor, I guess what I'd like to say is that what we learned in that trial is that Travis Reinking's mental state was, that he was schizophrenic was very clearly put in front of the jury. Like there's no dispute that they testified, and there were reports that he was that he had a severe mental illness, and that was schizophrenia. The jury heard that, right? His attorneys, I submit, did their level best, and I think Mr. Evans said in this hearing that he still believes insanity was the appropriate outcome, right?
Yeah, they both
Okay.
feel that the jury got it wrong.
They tried their level best to convince the jury and argue insanity. There was plenty of evidence of his mental illness and what was going on before and during and after before the jury. So they heard all of that, which is some of the stuff that I was going to show you, but not to belabor the court's time.
Oh, you can go ahead. I'm the one slowed you down.
Well, there's been some question about whether or not Travis Reinking knew the nature of his conduct. And that was a question that the jury heard testimony about. Now, if you look in the testimony of Dr. Rena Eisen, page 1858 of the trial transcript, my colleague was asking Mr. Reiking's understanding of, I am purposefully not going to shoot this man in the head immediately. I'm going to wait to do that one so that he might be able to ask God for salvation. That is definitely showing an understanding of the nature of his conduct. Correct. Her response, correct. The testimony of Dr. Mary Wood. Question, I think I want to, and this is page 1701 from the trial transcript. Question. Okay, I think I want to make sure we put to bed. You have no testimony here that Travis Reinking didn't know what he was doing. He knew that he was killing people, right? Yes. He could appreciate the nature of his conduct. Correct. I understand that they're making a slightly different argument, but I want to make sure it is very clear for this record that the jury heard testimony from expert psychologists that they believed he appreciated the nature of his conduct. And differently, page 1877 of the trial transcript, testimony of Dr. Wood. So you kind of prompted him of whether or not the victims had some threat to him. And his response back to you was they did not. Correct. That is, we submit that is evidence that he understood that he was not under attack. He was not acting in self-defense, and that he understood the nature of his conduct. I'll go on. There has been some testimony in this hearing that suggested, I think either from Dr. Spica or Dr. Agarkar, suggesting that Travis Reinking may have believed that he was shooting aliens at the time, that he was murdering these people at the Waffle House. That is not accurate. There was no testimony in the trial, and there's nothing in the records prior to this defense team coming in and speaking with him, in which he said that he was afraid of aliens. Travis Reinking believed that aliens were on his side, essentially. He was the leader of the aliens. And page 1613 from the trial transcript, testimony of Dr. Wood. You start at line 15, and these aliens, including one to whom he believes he's married, named Celine, ultimately kind of brought him to the attention of other people, that he had these brilliant ideas and this sacred knowledge that was of interest to other people. These were not his enemies. The aliens, quote unquote, are not his enemies. Page 1783 from the trial transcript, testimony of Dr. Rena Eisen. She, I believe this may be on direct examination. She talks about how he was writing about aliens. And if you start at line 11, although I've highlighted everything, he said they were poisoning him, trying to shoot him, but the aliens were stopping it every time. The aliens, and he reported concerned that the aliens might not be able to stop them every time like they had been. The aliens were on his side. Travis Reinking, the evidence was not in what he told the doctors and what he wrote about. The aliens were not his enemies.
Contrary to some of the expert testimony.
The testimony here in this hearing, that's right, Your Honor. And I'll move on from that. Their reflection and judgment, right? So there was some testimony in this hearing that Travis Reinking could not reflect and or judgment, and that's premeditation, as the court is aware. But there was trial testimony about this. The testimony of Dr. Rena Eisen, page 1836, starting at line 24. Question. And he said, this is Travis Reinking, he said, I realized I had to do something about the situation. And then that can, he said I had to do something about the situation. This is as part of a longer discussion, which he's talking about before he goes to Waffle House and what he's going to do. If you continue on, page 1856 of the trial transcript, testimony of Dr. Rena Eisen, starting at line 14. Question, you don't recall that Mr. Reinking said that he was going to punish them and take something that they couldn't take back, their lives. You don't remember that? Answer, yes, I do remember that. Okay, you remember that? Yes. Question, so you remember that he said he was going to punish them by taking something they couldn't take back, their lives? Yes. The fact that he's saying that he was going to punish them suggests that he's acting with reflection and judgment. That was put before the jury and argued. page 1857, in,
That was before the message from God.
yes, from God, that his statement was his choice. That was a question. Answer from Dr. Eisen, that that was his statement, yes. That he wasn't merely acting on a command from God, he was making a decision. I'll continue. Still from the testimony of Dr. Rena Eisen, and I think this is how I got messed up from one of the earlier ones, where Travis Reinking said, I started to think it through. Page 1837, lines 1 through 8. Question, I started thinking it through and I knew something had to be done at that point. Answer, yes. Question, so Mr. Reinking wakes up. Mr. Reinking realizes he has to do something. He makes a decision, correct? Answer, yes. Answer, he realized he had to do something and he said he asked for guidance from God, not a command from God. That's what the jury heard, right, about this command from God, that he was exercising decisions, reflection, and judgment. Dr. Wood, page 1698, line 5. Question. All right, now what he said in response to that, was he going to take something from them now that he couldn't take back? Answer, yes. Question, them stealing the car, them taking this car back, right? The police taking this car back from him made him so angry that he wanted to go out and punish people, right? Answer, I don't know that I would make that direct relation. He was upset about that. Yes. And I think that factored into the decision he made. That's reflection and judgment, Your Honor. And it was plenty of evidence to this regard put before the jury. And this is after they have already met with him, assessed him to have a severe mental illness, and such that they felt that he was legally insane. But there's still this evidence that the jury heard all of that, heard their descriptions, and obviously rendered a verdict of guilty, saying that they disagreed, which the jury was entitled to do based on all of the evidence. There was plenty of evidence, discussion about wrongfulness. Of course, there's been discussion in this hearing about wrongfulness, of course. In 1829, testimony of Dr. Eisen. Page 19. Question, he also reported to you that he tried to take punitive action by repossessing a BMW. Answer, yes. And he said that to you, punitive action. Yes. And Dr. Eisen, you would agree that when someone, and continuing on to page 1830, does something and says it is a punishment, that it's an indicator that the person understands wrongfulness, correct? Right or wrong discipline, if you're going to punish someone, they did something wrong, and so you're going to have a negative consequence to that. Yes, is the answer. The general concept. It does indicate that he understands that. There was, and I can continue on and on, but I think
Are you gonna submit a copy of this? to-
I can, Your Honor, yes, absolutely.
Well, I'd appreciate it, because, again, it helped me get focused on some of the important evidence.
Yes, Your Honor. I would like to direct the court's attention to page 1685 from the testimony of Dr. Mary Wood, lines 10 through 12. He's, again, saying that he perceived these people not as aliens, but as people, Your Honor. Okay? And now I want to go to the question of new evidence in this case, which is central to this hearing. And I've styled this section Reinking's mental state years later, and I think that that is extremely important. And before I go to the slides, what I want to preface this section by is saying that what you heard, the testimony from Paul Bruno and Luke Evans, is that when they met with him weekly over the course of 2 years or more, he was medicated. Mr. Bruno said, while medicated, he would even have Travis Reinking over to his house for dinner. That's a person who is no longer under the paranoia or the delusions that had taken his mind, right? That was very clear. He had been restored to competency. They had no signs or reasons to believe that he was incompetent based on all of their many, many interactions, is what they told the court. And therefore, what is clear is that he never expressed to them rigid delusions during their interactions. Travis Reinking did not talk to them about still believing that at that time in their conversation that he was hallucinating or any of those things. And this is important because the witnesses who came into this courtroom, Dr. Malcolm Speaker and Dr. Bhushan Agarkar, said something extremely different. And I know the court was paying attention and taking good notes, but one of the things that Dr. Agarkar said that stood out is that when he met with Travis Reinking, it was his opinion as a neuropsychologist or whatever his great title is, that Travis Reinking was presently under-medicated. And so what we learned is that if you look at his reports, Dr. Agarkar lists out the medication. This is a snippet of this one page from page 21. October 15th of 2018, Travis Reinking is discharged to jail with medications of Haldol. That's what he'd been prescribed at Middle Tennessee Mental Health Institute by the psychiatrist there to treat his psychosis. If you go on to pages 22 and 23, what you will see is that Travis Reinking's medication appears to be stepped down consistently. By the time that we get to January 23rd of 2024, he's taking Zyprexa and it's lowered to 5 milligrams. In April of 2024, 24th of 2024, on March 26th of 2024, he notes that he had a 30-day segregation. Certainly, as the court it's fair to argue, and the court might understand, that means him being around people is now changed. His situation has changed.
Once again, I object. The state has all the TDOC records. We put them into evidence. If they want to argue this, they can pull up the specific page from the TDOC record concerning that particular date and the reason for the segregation. They've not done so. They want to argue some sort of inference from what's in the report. I'm going to object to them trying to argue that because he was in 30-day segregation, it means he was some sort of danger or something in TDOC. We have no clue why he was put in segregation from the report.
That's not what I was said or what I'm arguing. My point is that his circumstances changed, which could have contributed to a further deterioration of his mental health status. That's my argument, Your Honor. And what we see is that in April of 24th of 2024, there's another 30-day segregation, a mental health screening, and now we're talking about the psychotropic meds, and he's being treated again for this mental health.
Well, are you saying that the change in medications, not only the type of medication, but the level, the amount, may have influenced the assessments that were done at the time?
That's exactly what I'm arguing, Your Honor. Yes, that's exactly what I'm arguing. Because these changes in medication, these 30-day segregations are occurring shortly before these doctors, who Dr. Speaker and Dr. Agarkar, are going to meet with him for the first time ever. Before then, the people who spent the most time around him, he didn't hallucinate. He wasn't expressing rigid delusions. By the time they get to him, for whatever reason, his medication has been such that Dr. Agarkar says it is too low. And what do they say? and these are the dates. June 20 of 24 is the first time that Dr. Speaker meets with him. 2 months later, just 2 months after these segregations is when he's coming to meet with Travis Reinking, right? Dr. Agarkar says he meets with him in July, just 3 months later. This is the first time. By then, he is expressing hallucinations, things that he didn't do before or during the trial, right? That's important because that is the issue of newly discovered evidence. Is this something that Paul Bruno or Luke Evans, through a proper investigation or reasonable investigation, could have known of? Well, no, because he was properly medicated such that he was competent, he was able to participate in all of their meetings. I think Mr. Evans said he even had insightful questions. They didn't have to go back over things and remind him of what they talked about in the meetings before. This is a person who was smart, who understood, who could participate in his defense and did so all the way up and through the trial. But what happens when we get 6 years later, he's somewhere else, he's not under the care of the same mental health team, and the medication is being stepped down. Now he's back hallucinating. That's the evidence that's been put before this court. And what did Dr. Speaker say? He's taking Zyprexa. That's his only medication. If you look at all the records there, you'll see he's taking in the past, he took a whole host of medication, especially during the time where it was contended that he was in psychosis. That's page 3 of his report. Page 32 of Dr. Agarkar's report. Remember, again, he says he responded somewhat to antipsychotic medication while incarcerated, but is being treated with a very low dose, which may explain why his delusions remain so prominent. Now, Dr. Agarkar and Dr. Speaker did not talk to Travis Reinking's family, not his parents, no one else from his family. They didn't talk to his legal team who represented him during the trial. So their understanding of when his delusions began start from the day that they met him in jail. And then at the present delusions start from the day that they met him in jail. And they can only then otherwise look back at these other records, right? They're not talking to people who are engaging with him to see, has he been having delusions before the trial or up until the trial, right? They don't know that. All they know is June 2024, he's got some hallucinations. Well, the medication has been stepped down. Dr. Agarkar, to this day, on page 6 of his report, to this day, Mr. Reinking continues to receive messages from the television meant only for him. These are rigid hallucinations that he didn't have when he was meeting with Mr. Bruno and Mr. Evans in preparation for his defense up into and through the trial. These are two people who testified that they are experienced, they are members of the Tennessee Bar, they are aware of their rules, obligations under the Tennessee of the rules of professional responsibility. They knew that if Travis Reinking began to hallucinate and they had questions of competence, they would have had to bring that before the court. Because he didn't, they never had any questions. They did not have any, they did not bring that to the court to question his competency because he never expressed these hallucinations, these delusions. Dr. Agarkar on page 32, I agree with Dr. Speaker.
If this whole argument's on competency.
No, it's on newly discovered evidence, Your Honor. Dr. Speaker says, on page 32, I agree with Dr. Speaker that Mr. Reinking suffers from impaired neurocognitive functioning and schizophrenia with active delusions. Okay, now the reason that I'm showing you this, where they're talking about these delusions that are rigid and ongoing in 2024, which there is no evidence that it existed in 2019, at the point in time in which Mr. Bruno and Mr. Evans got involved in this case up into and through the trial, is that Dr. Agarkar said something on his direct, and defense counsel, Mr. Johnson, actually put the term out there, which is to suggest that untreated schizophrenia can cause brain damage. Now, I'm making an argument that's twofold. One, I think Dr. Speaker's claim that there's brain damage is either false or at the very least faulty. But Dr. Agarkar is saying long-term untreated schizophrenia can cause brain damage. And what we're seeing here is that a man who was properly treated for some period of time, who wasn't experiencing delusions or hallucinations before, once Mr. Bruno and Mr. Evans got involved, up into through the trial, is now experiencing them. That means it is very well likely that if Dr. Agarkar is to be believed, that whatever brain damage that he may or may not have occurred after the trial. It occurred after the trial. Perhaps because of the fact that he is not receiving the proper medication now that he's in the Tennessee Department of Corrections. That is, it is to be believed that he actually has brain damage, right? If it's to be believed, it is likely that this is not newly discovered evidence because it's not evidence that could have existed at the time, Your Honor. The second part is my challenge to Dr. Speaker's claims. I don't have any slides on that, just argument. Dr. Speaker came into the courtroom and he presented as if he could say with certainty that Travis Reinking suffers from brain damage. In his report, he said it was unspecified neurocognitive disorder. Unspecified. And that's an important term, or the root of that. Specifics. When I asked him about the 30-some-odd reports that tests that he gave Travis Reinking, he could not testify with specificity or with certainty. Again and again, he gave vague answers. He wasn't sure. He believed he tested in the normal range, or maybe the low normal range. Those answers were vague. He didn't. It's one thing to not bring the raw data in. It's another thing to come into this courtroom and not actually submit how he actually did. And he didn't present that information. Yet he was confident and certain that he could tell you specifically that Travis Reinking doesn't have an unspecified neurocognitive disorder. He has essentially traumatic brain damage to the front temporal lobe. That is different from what he put in his report. He expanded his testimony, which is why we made the big deal that we did yesterday morning, because there was no way we could know based on the code that he put in his report what he was going to say. Now he's saying he has brain damage to the front temporal lobe, and when questions were asked to him, not just by me, but by the court, he essentially said that damage occurred all the way back before he even, perhaps as early as the mid-2000s, as a result of injuries he sustained as a child. Now, that is inconsistent with the evidence that was also in this hearing, which is that when Travis Reinking showed up on April 22nd, 2018 to that Waffle House with an assault rifle, he drove there himself. He was a high school graduate. He had done 2 years in college. He got A's, B's, and C's in classes: algebra, microeconomics, trigonometry, chemistry. He got a B in physics, college physics, no matter how much Dr. Speaker or Dr. Agarkar might want to minimize that. That is not an easy thing, as Your Honor is probably aware. He operated.
Hey, when it comes to math, I'm very aware of it.
He operated a crane. He was a licensed crane operator. That is certainly not an easy job. It's not just like you put your hand on the joystick, okay? This is a difficult job in which he had to receive a licensure, a certification, and in one of them, in those records, he got a 97 out of 100. Dr. Speaker couldn't even agree that that was showing that he'd done a pretty good job on that test. He was here in Nashville living by himself. He had an apartment. He was playing video games. These games are not Pac-Man again, the little joystick game. This is something that is more complex. Call of Duty. He is playing them against other people. People who aren't just doing the same thing, routine that a computer generated will do. They have their own spontaneous things. He's responding, he's reacting to them. They require his mind to process and react, for him to learn new things and to get better. Your Honor, because we don't actually know how Travis Reinking did on the full battery of tests administered by Dr. Speaker, the state submits that this is insufficient to conclude that he has brain damage. The evidence, that the fullness of the evidence that is in the records here suggests that Travis Reinking can learn new things because he met with his attorneys and talked about his case over and over and over again. That he does have the ability to remember things because he talked about what he did at the Waffle House on April 22nd, 2018, over and again. And he described not only what he did, but what he was thinking, with detail, Your Honor. I guess I will conclude with saying this. What this honorable court is being asked to do is extraordinary. I understand you take your role with great seriousness, but the defense is not and cannot and will not meet its legal burden that is required for the court to overturn this conviction. If the court is going to overturn this conviction, it needs to rest on a foundation of legal precedent and evidence that is as strong as granite. What they have presented here is just sand shifting. We ask that you deny this motion, not based on feelings or emotion, but based on the evidence, all of the evidence. Deny the motion, and thereby give these families some peace.
Thank you, Mr. Downing.
Just I think it's one thing in response to a question Your Honor asked
Yeah.
about the jury not being able to consider the mental health and premeditation, which that is part of the charge. That the jury premeditated acts, exercise reflection and judgment, the mental state of the accused at the time must be carefully considered.
Yeah, but I just, it seems to be in conflict with the provision that they're not to consider insanity at all until they first found guilt. That's a puzzling. I understand there's no law one way or the other, but the way, when I'm looking at it now, it causes me some concern.
But if you look at the entire record.
No, I understand. No, I understand. It's just something that, it's one of those facts that you've got to look at and think about in the context of the entire record. Some things you don't have to pay much attention to. They don't raise possible red flags. That jury charge makes me want to look at everything as a whole. That's all I did.
And that after looking at everything in the whole, the jury would not have found.
Yes.
They would have reviewed it, would not have found it.
Yes, I'm just saying that that's one of those things that I think is worth looking into and scrutinize more closely. Okay, Mr. Johnson.
want to hit that, if the court pleases the court, I want to hit that some of that last stuff about Dr. Spica first. And I will note, though, that other than just argument that we've heard, we don't have any contrary expert testimony. And they had every opportunity in the world to obtain it, even just to get someone to look at the data and see whether or not there was a contrary interpretation of it. And that was not done. With respect to Dr. Malcolm Spica, you have before you testimony from both Dr. Spica, forensic psychiatrist Dr. Shawn Agarkar. You know Dr. Agarkar's credentials. You heard them. He has testified all over the country. He's done work for the Department of Defense. He's been in Guantanamo. It's a matter of public record that the state of Hawaii has gotten him to come in and reevaluate the way they do their forensic mental health work in their prison system. Dr. Agarkar's testimony was that the medication that Mr. Reinking was receiving and has been receiving, there's a reason why he detailed all of that going back to the Davidson County Jail in his report, does not affect the validity of his forensic opinion and forensic analysis. And the court has no contrary evidence before it on that point. Number two, with respect to Dr. Malcolm Spica, Dr. Spica testified that the medication that Mr. Reinking is on did not affect the validity of the 3 different sets of neuropsychological testing that were done by Dr. Spica. And in fact, the medication that Mr. Reinking is on is going to enhance his performance on the neuropsychological testing, not make it degraded. And that when Mr. Reinking is completely unmedicated and untreated, then those deficits are more likely than not worse than they showed up now in the neuropsychological testing. The medication issue, as far as the testimony before the court, that untreated severe schizophrenia over time can cause severe brain damage. It was a testimony of both Dr. Agarkar and Dr. Spica, as the court will recall, that untreated alone is not the type of neurocognitive, is not going to cause the type of neurocognitive deficits here. They would expect to see a general decline over the course of all cognitive function. But that in and of itself can cause some of the decline. Here, as Dr. Spica testified, given the particular focal points that are very focused on the neurocognitive deficits, those are more likely than not more directly attributable to the brain injury, to some sort of injury, closed head injury, something other than just only untreated severe schizophrenia. So that is the uncontroverted medical and neuropsychological testimony before the court, and I just want to make certain that is clear. That's what those issues are. Now, with respect to what Mr. Evans and Mr. Bruno testified to about their observations and their interactions with Mr. Reinking when he was jailed at the Davidson County Jail after he was on a very high dose of antipsychotic medication. If you recall, Mr. Evans admitted Mr. Reinking had problems with memory. He had problems remembering things. He had problems remembering things concerning what occurred during the commission of the offense. He had some difficulty remembering things from meeting to meeting. The court heard that testimony from Mr. Evans. Number two, Mr. Bruno testified that he's represented a number of individuals who have had mental health issues. Just talking and interacting with those persons is not going to let you know whether or not they've got some sort of mental health issue or even a neurocognitive disorder, given that there is such a broad spectrum of different types of neurocognitive disorders in the way in which the brain functions. That is the actual testimony that is before the court on those issues. To the extent that the observations of Mr. Evans and Mr. Bruno when Mr. Reinking was very heavily medicated while in the jail matter at all, I wanted to make certain that record is clear before the court and address those points that were argued by the state. As far as what Mr. Reinking was able to do, first of all, Dr. Speaka never said that Mr. Reinking suffered from traumatic brain injury, a TBI or TMI. That's not anything that he testified to. I think that was just a misstatement by counsel. He has severe neurocognitive deficits in those three areas. As far as he took math and was able to take math, if the court recall from the transcript, he failed twice, and the community college allowed him to retake it. That goes back to and provides some support for the fact that he does have this learning deficit with respect to new memory, but if he does things multiple times, he can overcome it because in other ways he is intelligent. Now, he retook those classes. The court will also recall the Crane certification records, which we put into evidence. They're in evidence, and there's a summary of them that are located in the expert reports. He couldn't pass the certification test twice. He retook them. He was able to get passed. And the court will also note that where was he a crane operator for the most part for his dad's company? And for the most part, he was living upstairs at an apartment at his dad's business. It's uncertain how much work he really did as a crane operator. He did have a crane operator. I'm finishing. He did have a job as a crane operator for a short period of time in Colorado, and he didn't make it on the job. Those are the employment records that exist. They're in the record. Now, with respect to ineffective assistance of counsel, an argument was made that given that counsel for the state would turn over every stone and they would uncover if someone got into the jail and was meeting with Mr. Reinking, and they would find that out. That goes back to, was the defense so scared of its shadow that it would be afraid in a severe mental illness case that, God forbid, they actually decided to consult with a psychiatrist and have a psychiatrist meet with their client? But beyond that, the testimony that's before the court is that both Mr. Bruno and Mr. Evans testified that they knew that there was the opportunity to get a court order under Ake versus Oklahoma that instructs law enforcement to keep that information ex parte, not disclose it to agents of the state. And I can represent to the court that I have a significant amount of experience in handling these types of cases, and those are the sorts of things that are done. That's why I asked those questions of Mr. Bruno and Mr. Evans. And they both admitted that that's... But nothing would prohibit, let's take that issue aside for a second. Nothing would have prohibited Mr. Bruno or Mr. Evans. Let's not even go to the step of getting an evaluation done yet, or anyone even meeting with Mr. Reinking yet. They didn't even have a consulting psychiatrist to help explain to them, to look at the records from Dr. Eisen in Middle Tennessee Mental Health, to look at the records from Dr. Wood at Vanderbilt, and to look at things, and to look at the fact that, and the testing wasn't able to be completed at Vanderbilt because he was too psychotic. The testing wasn't able to be completed at Middle Tennessee Mental Health because he wasn't psychotic. Here's what you need to do if you really want to shore this evidence up and really investigate it. You need to do X, Y, and Z. You need a psychiatrist. I think you need to get neuropsychological testing. They didn't even consult with someone that would let them know how they needed to investigate an issue that is not just a psychological issue, but is a medical issue, a psychiatric issue, which is why they needed a psychiatrist to consult and explain these things to them. And counsel for the state didn't touch on that at all. But that is a significant issue. Mr. Evans never said in testimony that he rejected the diminished capacity defense because the evidence of intent and premeditation was overwhelming. He never said that when he testified yesterday. He said that he rejected it because jurors didn't like it in his prior cases. But he also admitted that in one of the cases he presented evidence of PTSD, and it wasn't a severe mental disease or defect, which is why he was presenting it as diminished capacity evidence, because it just requires mental disease or defect. And in the other case, he couldn't remember what it was. Neither one were severe mental illness, severe schizophrenia. And as the court said, just because you may try 2 murder cases and lose 2 murder cases, does that mean you never try 2 murder cases again? Does it mean you're never going to insert a self-defense again because you've lost it twice? Every case is case specific. And for him to just have done that, admittedly, analysis, he says, in his head, not confer with Mr. Bruno about it, not confer with Mr. Reinking about it, not confer with any other member of the defense team about it. The uncontroverted testimony before the court is neither Mr. Bruno nor Mr. Evans conferred with this third lawyer who was on the team, the conspiracy theorist, Kurt Haskell. They didn't confer with him about diminished capacity. They didn't confer with Mr. Reinking about diminished capacity. They didn't confer with the mitigation specialist about diminished capacity. They didn't confer with their jury consultant about diminished capacity. They didn't confer with their investigator about diminished capacity. The testimony is they didn't confer with anyone about it, much less their client. And I think it is a salient point. They did have this Mr. Kurt Haskell on the team. They expended significant resources to investigate all the electronic evidence as to whether or not Mr. Reinking was really receiving messages from the CIA or FBI or some unknown entity thing that was part of his delusion, or whether or not the videos from the Waffle House had been fabricated. They expended defense resources on that issue, and the court knows all too well how expensive that can be. Didn't even investigate the mental health evidence and get someone just to consult with them so they could better understand the evidence here. Multiple times, Mr. Bruno and Mr. Evans, when they testified yesterday, when I posed them questions about what they asked Dr. Eisen or Dr. Wood, they both said, I didn't know to ask those questions. I didn't know to ask them what else they needed to do or what other testing they need to do. At one point in time, Mr. Evans, I believe, said, I'm not a psychologist. I think he said, I wouldn't know what to ask. That drives the point home harder than anything else from their testimony, I think, other than the fact they said they just didn't even investigate it at all. They didn't even know the questions to ask of the court-ordered evaluations that were admittedly more limited in nature. As far as this issue of nature, and I think, and Dr. Spica said this to one of the court's questions. He said, Dr. Spica said he's not sure because Mr. Reinking's delusions are very fluid as to whether he considered he was shooting at real people or people inhabited by aliens, because in his delusions, at different times, agents and CIA agents and people from, or this amorphous entity can inhabit other bodies and give signals. And so I think that's what the issue was. It wasn't that necessarily Mr. Reinking said, or Dr. Spica said, he thought he was shooting gray aliens. It's a more nuanced, complex, fluid, chaotic mental state here. And part of, at times, you know, when you read the Crazy Journal or in all the medical history and other things concerning Mr. Reinking, it's clear that aliens possess other people's body. It's fluid as to whether or not they're helping him at times. At other times, there's this amorphous CIA, FBI entity, and then, you know, the various Taylor Swifts and alien wives that he has. At the end of the day, trying to assign rational thought to a person who has that chaotic and unstructured thought process from his severe mental illness is not something that we can do. And it's one of the reasons why the law calls for, in these sorts of situations, professionals who have been trained to do so. And the evidence before the court is that there was an incomplete legal insanity defense that was presented at this trial. And that incomplete legal insanity defense fundamentally altered the strength of the evidence that the defense was going to present in a case where the only type of defense where you're assuming the burden of proof by clear and convincing evidence. When mental health is the ballgame, it's the only defense here in the case. And so knowing that at the guilt-innocence phase of a trial, when your mental health is only relevant in two ways, insanity and diminished capacity, you don't even investigate the other way in which it is potentially relevant to be presented to the jury. That is a fatal flaw here, and any deference that would normally be given to a strategic or tactical decision cannot be given. With respect to the improper prosecution argument issues, I'm not going to spend a lot of time there. I think Ms. Fuchs covered those very well. But I will say this, with respect to this argument that because Mr. Reinking said evil, then that just let the state loose to use the word evil however many times they did. The context in which Mr. Reinking said that was in the course of this command from God. It seems evil, but God told me to do it. And that's the context in which it was said. And so using those words in a very different context and then calling the defendant specifically evil is a very, very different thing. And that's what they did. And that is wholly improper. Counsel for the state went through a lot of the testimony that occurred at trial from Dr. Eisen, Dr. Wood, this reference to Dr. Kovac, who, by the way, did make that progress note in the course of the weekly sessions with Mr. Reinking early on when they were trying to restore him to competency. But then, of course, as the court saw a couple months later, he signs off on the opinion by Dr. Eisen on legal insanity. And the fundamental flaw in all of those arguments by the state is, yes, why they feel like they presented substantial evidence concerning intent and premeditation, and Dr. Wood and Dr. Eisen really couldn't comment about nature of the offense. As the court's aware, nature of the offense has to do with, I'll go back to it. Here it is. Cognitive capacity of what the actions were. Dr. Brown and Dr. Eisen were unarmed with the knowledge of the neurocognitive deficits. And that alters the analysis and makes for a more complete defense. So we can talk all day about what Dr. Brown and Dr. Eisen's testimony was. And Mr. Evans and Mr. Bruno both testified that even though Dr. Eisen was super strong, she deflated in front of the jury. I think that speaks to the ineffective assistance on really understanding, presenting, researching, investigating the mental health defense in this case. my final point, and I'm gonna put this slide up. I said it before, and I'm gonna close by saying this again. This, of course, is a significant case. These, of course, are significant issues. These issues are not presented every day at a motion for new trial. And the court has before it substantial evidence that neither it nor the jury got to hear. The court now has a more complete picture of what the jury should have heard. And critically, the jury instruction, if this evidence had been developed and presented, the jury should have gotten. And we cannot have confidence in the outcome of the result of this case. There has been, I respectfully submit to the court, an undermining of confidence in the outcome. And justice prevailing requires the grant of a new trial. Thank you, Your Honor.
Thank you.
Judge, can I address some of the comments you made during your comments?
Now what?
You made some new comments. Can I address some of the arguments? It will not be lengthy. And it goes back to the request that I made, was that yesterday or the day before? About the state's request to have an expert. He's making an argument to you to ask you to consider evidence that we specifically asked that we be allowed to put on additional proof.
And what's that specifically?
He is arguing that Dr. Speaka's testimony, that the court should accept it as true, that somehow he had cognitive deficits that existed in 2018, even though he could not explain to you how what his testing, which again, the state is not conceding that his testing is correct, but that how his testing could not have been caused from a head injury. You heard the testimony of, it's Travis Reinking that said James Shaw Jr. slammed his head into the concrete and he saw stars. It could have occurred at that moment if we are to believe Dr. Speaka. There's nothing that says from that moment in 2018 until he saw him 6 years later in 2024, and when he's been in jail, that he didn't hit his head ever. There's nothing to show that this was caused by something that occurred prior to April 2018. If the court is going to consider Dr. Speaka's testimony where he gave no nexus to explain to the court how the deficit would cause him to not be able to form the intent, how the delusions would cause him to not be able to form the intent based off of these three tests, when he can't even explain the entirety of his testing, but he never gave that nexus to the court. But he also cannot say, if his results are those, that there wasn't some injury to his head. He can't say that. There is nothing before the court that makes Dr. Speaka's testimony reliable for the court to consider it in this way. And if the court disagrees with the state, we absolutely are asking to be able to obtain our own expert. His report did not indicate what his testimony was on the witness stand. We were not provided notice. That is unfair to the state. And if the court intends to consider it, which again, the state's position is it is not reliable evidence for your honor to consider. The fact that both of those defense experts said that he was having fixed, rigid delusions when they met with him, and none of that was happening for 2 years when he was meeting with his trial attorneys, that is an indication right there that something happened after, not before. There is nothing other than the actual evidence in this case, and judge, the evidence that Travis Reinking, and most insanity cases, we don't have defendants that are writing out a blow by blow of what they did, how they did it, and also unreasonable that Luke Evans and Paul Bruno would not consider diminished capacity. There were 18,000 statements of Mr. Reinking talking about his intentional acts and what he was doing, and it was intentional and purposeful in his actual thoughts. And the delusions were not preventing him from doing
They're
that.
going beyond your speaker argument.
Judge, the speaker argument is the diminished capacity argument. The state, we have a request that if the court is going to consider it, that we be.
Well, I mean, I have to consider it's been presented to the court.
Then the state is requesting that we be able to obtain
Okay.
an
But here's
expert.
again my question, and I brought it up yesterday, and then we got off tangent. What specifically is the area of testimony that he presented that was not in his report? Because in the report, he gives the 3 deficits. He gives his opinions. What is it that he was testifying to that came out of left field?
Number one, he didn't put in his report that he had a brain injury, that there was damage to his brain. That's not in the report. It's not. And Judge, there's nothing about the fact that this damage to his brain tissue was such that he can't form intent. That's not in his report. He is, whatever that 49 diagnosis is, we looked it up. It's the vaguest thing on the planet that they threw in there that doesn't really mean anything. And then he says he did badly on 2 memory tests. Well, 2 memory tests, Travis Reinking went through and explained exactly how he killed all of the victims right after this happened. Whatever memory issue he might have in 2024, 2025, he did not have in 2018. His journals recount incidents in 2016 when he's in Tazewell County.
Okay, well, hold on. He says in here, Mr. Ranking's mental capacity at the time of the charged offenses was diminished to the extent that it rendered him wholly unable to form specific intent and premeditation.
Right, he makes a conclusory statement based off of an unspecified.
No, I understand that, but you said that the diminished capacity was not in his, anything about that was not in the report, it's right
I
there.
didn't say that. I don't
I
believe you're
misunderstood then what you said on
I
that.
said, there's nothing in his report that indicates that his brain tissue was damaged. He's saying he failed a memory test. Those are 2 very different things. 2 very different things. And that is one of the issues that the state has with his testimony, is the state has reason to believe that doing badly on that test does not equate to the fact that you have damaged brain tissue and you can't form this intent. He went past his report. And we were very adamant that that was not something that we were put on notice of. And I am still as adamant as I was the other day. It is unfair to the state that we were not allowed to pursue that. This was information that was not in the report. Whatever he wants to say, it doesn't say damage to brain tissue in the report anywhere. That is not in there. That is much bigger difference than I scored badly on a memory test 6 years later. Who cares? That doesn't mean anything. He made a leap to somehow this all occurred before 2018. And for them to be able to argue that diminished capacity is relevant to this trial at all, they had to get Dr. Spica to have damage to his brain tissue. That is how absurd it is for their argument about Paul Bruno and Luke Evans to have investigated it. This is absurd, but it is wholly unfair to the state and to the victims in this case for us to not be able to follow up on new evidence that we were not put on notice
Okay.
of.
There's so much wrong there. I'm going to try to tackle it succinctly. So, number one, Dr. Spica never said, and there's been no testimony, there's damage to brain tissue. The issue is neurocognitive deficits damage to brain tissue is different, it's observable, it's on a scan. There's not been any issue that there was damage to brain tissue. What the testimony was from both Dr. Agarkar and from Dr. Spica was that another way to describe a severe neurocognitive deficit can be brain damage. You Google severe neurocognitive deficit. What comes up? Another way to describe it is brain damage. It doesn't take a lot of research based on the report to figure out where the opinions are or what they are. Furthermore, the report is very clear about what was reviewed, what tests were done, a summary of the history that's relevant, information concerning the tests that reveal severe neurocognitive functioning that converge together and create the diagnoses, and then the application of that diagnosis to the forensic opinions. And so all of that is there. Now, I have made plenty of arguments as defense counsel before when I have no authority, and I have said, that's unfair. I'm sure you have heard a lot of that from defense lawyers through the years. They're the state, and I specifically said yesterday, if they've got any authority, let's hear it. And then I rolled through the authority concerning this. Rule 16b on putting together a report only applies at trial with respect to defense evidence. We've got no obligation to give discovery at a motion for new trial hearing. In motion for new trial, we can submit evidence and affidavits up to the day of the hearing under Rule 33. However, we did not do that here. As soon as we were able to get evaluations done and his security status was stepped down, we had those evaluations done. And so in February, the moment we got these reports back, we were filing them, sending them to the state, sending them to the court, filing them in the court record, so everyone would be on notice about this. And if the court will recall, in one of our status calls, shortly after we filed these reports, when we were discussing scheduling, I said we need to factor in whether or not the state wants to attempt to have any of their own evaluations done. That never occurred. They could have picked up the phone, they could have consulted with a psychologist or a neuropsychologist about this, and they did not do so. There's no unfair surprise. If the only surprise that can be articulated is some sort of brain tissue damage, there was no testimony about brain tissue damage that ever came in. And so, and then also the state's position on this is kind of shifting around all over the place. Yesterday, at the end of the day, their position was, well, Judge, you can consider this as to ineffective assistance. It's only if you reject ineffective assistance and consider it as newly discovered evidence, does the state want to get an expert and stage it and get an expert to look at the test data. And so now I think they've got a different position today. I'm not certain. Our position is very clearly, for the record, we object at this late stage for them to get some sort of expert to do some sort of evaluation of Mr. Reinking. If the court does allow that to occur in some way, then, at the motion for new trial stage, which would be highly irregular, if the court does allow that to occur in some way, it's got to be a properly qualified expert who knows how to look at these neuropsychological tests, which yesterday it was very clear, counsel was clear, they didn't confer with the neuropsychologist when they came in here and made those allegations they made on the record that were unfounded, unsupported by any evidence. And so that is our position, Judge. It's my understanding that that's an issue the court is certainly taking under advisement. And I wanted to make certain our position is known for the record and that those inaccuracies stated by counsel for the state are corrected in the record as well.
First, on the issue of brain damage, I'll go ahead and tell you, that's not the way I understood it. And I will not make a finding that there was brain damage. That became kind of a colloquial term that was being used to describe his mental situation, but I don't put any weight into brain damage. Zero. I'm relying on what's in his report and his clarification on some of the issues that he has in this report. But I'm putting no weight whatsoever on the term brain damage, physical, that there was physical or that there's otherwise considered brain damage under some psychological approach. He's got cognitive deficits. I'm going to look at the DSM-5 myself and see how they define it, because they talked about it, he based his opinion on it. But brain damage is not a consideration of the court. That's not the new evidence that I perceive as being argued to justify a new trial. It's the reports of cognitive deficits that could have been found or could have been established pre-trial, okay? So, but, I mean, if that is the concern, don't be. I'm not relying on anything dealing with brain damage. I will give what weight I think is entitled on his causation factors and things of that nature. All right? And again, I'm gonna be looking at the totality of the circumstances surrounding him and that, and I understand everybody's arguments, and I feel I've made notes on the arguments that I think are valid that I need to particularly weigh on those issues. So, I don't need another expert to come in and give me another opinion, because that really doesn't go to the issue of whether or not there's new evidence. That just goes to the issue of whether or not the new evidence can be contradicted. But I will give it what weight I think it's entitled to under all the circumstances. Okay? So I do
Thank
not
you, Rob.
feel, and I'm not going to postpone, other than my opinion, for purposes of trying to absorb everything, to postpone this matter for further proceedings.
Your Honor, we're making a flash drive that has the PowerPoints on there. We'll put the state's PowerPoint on there as well.
Yeah, I would like anything and everything, because it just helps me reference this stuff quicker and look at it in full context. And
Could we make that, obviously since it's for demonstrative for ID only, could we make that for ID only exhibit number, I believe it's 12?
Yeah, ID
To this
12.
hearing? And we'll make that flash drive real quick for
Yeah.
the court and give it to the clerk. Thank you, Your Honor.
Judge, we do have a request to ask Your Honor to review the entirety of the trial transcript.
Oh, I know.
And we've already put into evidence the, I believe, we did, yes, before one of the arguments. We put into evidence the entirety of the trial transcript, General Sessions Court transcripts, all pretrial proceedings, sentencing
And
hearings.
I will be reviewing it all.
Thank you, Your Honor.
It's, I'm trying to follow